Young Jurks. What's up, Jerks? It's Mike Crawford hosting tonight. Have a great special guest back on the show, a friend of the show. Excited to have him back here, especially after watching what was going on at the Wilbur Theater. I know a lot of you saw him there. If you didn't, you probably saw the pictures. So definitely want to hear a little bit about the Wilbur Theater tonight. And also, everybody's been waiting to see about this mega motion. Has it been filed? People want to know if it's going to be out tonight with Aiden Carney. But we're the big story of the day that we're definitely going to be focusing on tonight is Kelsey Fitzsimmons. Breaking news. We just posted it up on our Twitter that the judge denied the reconsideration to have her the revocation of the bail, I guess is what we're calling it. But there was a motion to reconsider her ruling that just happened on I think it was Friday. I'm trying to remember. It's happened just a few days ago, and the judge denied it. We have that motion. We have that ruling. Have the document in front of me. We may take a look at that today. Hoping attorney Mark Bederow saw it. We have him here. Let's bring up attorney Mark Bederow. Hey, how you doing, Mark, today?
Good. How are you?
Great. I should say super chats right at the end of the show too for people. We read them at the end. I just saw one come up. I appreciate always the super chats, but we read them at the end. But I'll just throw this one out because I didn't say it yet. Monster Mega Mark Motion. They're all looking for it. Uh, I mean, are you done with it? Are you still working on it?
Uh, the
Reviewing
legal
it?
the legal work is done, but there are layers to this thing. So it'll be released when it's ready. If it's ready tonight, that it could be. But if it's not, we go on quality and that kind of thing rather than rushing it out. So I really don't know, to be honest with you.
So we're definitely not going to get docketed, so people don't have to keep hitting Mass Court's website and trying to refresh it looking for it. It's not good. It's not going to be out there tonight. Is
I would
bottom
not
line.
check mass courts to be wasting your time.
Yeah, not tonight. Maybe tomorrow.
Maybe.
Because we're all fanatical about filings and just everyone wants to see them as soon as they come out, read them over. Everybody's waiting for that one. I just mentioned the Wilbur Theater. You were there for what was it? Not D Deb versus Turtle Boy was the official name of it, I guess, right?
I think
What?
so.
Yeah. So how was that? I mean, you look like you were treated like a rock star there. I saw the
Uh,
entrance with the glare and Melanie Little, and people went crazy, didn't they?
They did. I mean, there's a lot of energy in that building on Friday night, so I think it was a successful event. A lot of humor, some crude, some not so crude. You know how it goes with that stuff. But no, I think it was very successful. People were happy to do it. Looks like they wanted to blow some steam off and just get together, and a good time was had. And there were after party events and things like that. And I think it was just a good time. I think everyone who went enjoyed it, except for maybe, you know, the few trash bags that got thrown out. I
Were
don't,
they thrown out? Were there people that showed up
I,
that got thrown out? Did they?
I don't even know. To be honest with you, I mean, the whole the whole story about the drink and whatever. I don't think it was intentional, at least in the sense of being directed to me. It was an intentional act, but whoever the lady was who threw the drink clearly didn't major in physics in college, because when you have an open glass and you want to throw it at someone in the front, it helps not to start by going back and then launching forward, because you're going to throw it backwards where I was standing. So, whatever.
Was that at the Wilbur itself, or was that after?
It was at the Wilbur in the
At the Wilbur.
kind of near the main entrance area, maybe in the back of the theater into the going into the lobby or whatever.
God, was that at the beginning of your show? Or at the end?
I think it was in the middle. I think it was intermission. I think people were a little frisky and excited and amped up and liquored up, probably some of them anyway. And I mean, look, it is what it is. It's a little stinging in the eyes. It was not water, I can tell you that. Water doesn't sting like that. So, but
At least you're not allergic to it. You probably are like, oh, that's all right.
No, I think it's more stunning than anything else when you just get a drink, full blast from, less than a foot away, square in your eyes. Yeah, it's a little shocking, but kind of fits in a little bit with this crowd too. It's a little crowd's a little raucous at an event like that.
I once had a girl, a lady, throw up on me in the middle of a bar like that. I didn't know. Like
I,
that's the worst. That
I
is
I would take 10 drinks in the face before one vomit. Absolutely.
lucky. I had a lot of friends there that had like clothes in the car. Like
Yeah,
I'll never forget that. That was funny.
but it
Um,
really wasn't that big a deal.
yeah, you were good. Um, so yeah, so you got on stage as well. I saw, and I heard you threw some kind of shade or a little bit of a roast at Turtle Boy. Maybe what did you say on stage?
I guess you could call it a former roast. I mean, it was clean. I don't, for a lot of reasons, wouldn't participate in some of the stuff that a lot of people might say, but it was more or less around the lines of, I need a break from this. Just, let me do something else. Let me deal with something else and just let me be a lawyer for Christ's sake without dealing with crazy drama and trauma every second of what feels like every day. But it's all in good fun. It's all, all part of the evening. So it's all done in good spirit.
We call that a better roast. Better roast.
A little bit, but
Yeah,
yeah, I mean, whatever. It was fine.
excellent. And so we're talking about this Lindsay, Kelsey. Excuse me, I said Lindsay. I keep doing that, Kelsey. I don't know
Yeah,
why. I know
I
why.
can't talk
Is
about
that
that. I can't talk about. Yeah.
yeah, no. We're talking about Kelsey Fitzsimmons. There's a ruling that just came out, but you made a post, I think it was yesterday, about this whole thing, about the fact that she got lugged because she couldn't breathe into a tube because she's got severe lung damage, liver damage, diaphragm damage. She's got all kinds of issues from getting shot.
Yeah, bullets will
Uh,
tend to do that when you get.
yeah.
Yeah.
What do you think about this? What's your kind of viewpoint of this whole thing?
I mean, it's concerning. As I said, there appear to be a lot of red flags. It feels as if the boundaries of Chinatown and Massachusetts maybe extend beyond Norfolk County a little farther north. Um, the way that case has been handled, you had a grand jury that tossed an attempted murder charge and left it with a much lesser offense, which is a very rare thing. That's a red flag. You have the police there because of an incident involving two parents that are fighting over a child. That always raises issues about people who may or may not try to exploit the criminal justice system to get an edge in a custody proceeding or that sort of thing. Um, Everybody knows that this woman suffers from postpartum depression, which is no joke. That's pretty real and can be really serious. I mean, you've read about some horrible, horrible cases where it ends up really bad. So you have just all kinds of red flags about this. And then when you find out that, bail is essentially revoked over what appears to be a hyper technical issue and a very ticky tack evaluation by a judge who appears, I don't know anything about the judge, to be honest with you. I don't really know anything about Fitzsimmons, to be honest with you, other than chit chatting briefly with him about it, right, and reading about whatever is online. But you seem to have a judge who seems very hyper technical and very aggressive in the rulings. I did see briefly the decision that I guess came out today denying reconsideration or after reconsideration not changing the ruling, and I only perused it. I didn't study it. I don't take notes or anything like that, but my impression was it sounded very hyper technical, and it also sounded very snippy. It sounded very snippy and almost personal between judge and lawyer, and that's never a good thing when client potentially gets stuck in the middle of that. References to suggesting that maybe the witnesses that were put forth or the evidence put forth by the defense, were not reliable, or purported emails. When you start seeing words like that in a judicial decision over something like this, that's another red flag for me. That feels, um, I don't want to say vitriolic, but it feels snippy for sure.
Now it seems like this judge may have worked with Tim Bradle. Um, I see
I
that
think
she's from
so.
Suffolk County.
I think if you just do the math, there's got to be overlap. So I mean, I don't know. It's not something to really address, and wouldn't. But if they both worked in the Suffolk DA's office over whatever period, and there's some kind of overlap, you have to wonder if that's a factor. I don't know why it would be. It shouldn't be. But at the end of the day, sending a woman with these issues back to jail over difficulty with blowing on an alcohol test because she's full of lead and has other injuries from being shot, and then suggesting, as she did in the decision, that there was some kind of gamesmanship or disingenuousness. I thought that seemed a little low blow as well in that ruling that came out today.
Especially knowing she hasn't tested positive for alcohol. Like it'd be one thing if there was indication she was drinking, but there's no
You know,
indication that she's drinking. Like there's
yeah,
no, so
yeah.
what's,
Well, this is what's interesting. And again, I don't know in the weeds of Massachusetts practice how probation works with the court and whatnot, but I can only tell you my experience, okay? And you can start with in federal court, what the pretrial services and the probation people say is treated by a federal district judge as gospel almost. They are like, if they have an opinion, it carries a ton of weight. All right. In New York State Court, it carries a lot of weight with a Supreme Court judge, what we call them here, in terms of recommendations for things. And I found it very interesting in this case that probation was sympathetic, understood, and indeed supportive of what Fitzsimmons was proposing. And to see the judge kind of go against that, go against the defense. And as far as I could tell, and I could be wrong, I didn't listen to the whole, what do they call it, FTR in Massachusetts. But I also, from what I could tell, there seemed to be a missing analyst in all this, asking the DA, what do they think? Because that
where
can
was the
put
DA? Yeah.
the judge,
Because I listened
if
to it.
you
We can listen to the tape. I have the tape, and we can listen to it again tonight. But yeah, I didn't hear the
always
DA at all, really.
take the input of the DA, and if the DA's position is we're okay with this, now that doesn't always make a judge do, and people think in Norfolk County it does, but it doesn't always make a judge do what the DA recommends. But in a situation where the defense, probation, and DA agree over something like this, which is the ultimate ticky tack nonsense to throw a young mother who has postpartum depression and is full of lead in a jail cell, to not even, as far as I know, query the DA. And who knows? I mean, the DA might have agreed with the defense only out of fear of looking terrible by being vicious in seeking it. And the other thing that the judge, you can't ignore is the level of case is substantially less than it was initially when the
Right.
dangerousness hearing was sought. Okay. This was an attempted murder case, right? The theory,
Yes, it was.
the theory of the DA's case, as I understand it, and if I'm wrong, someone will tell me, because I have not studied this. Let me be very clear. I don't even remember the judge's name, so give me some grace on this. But the my understanding of the theory of the case is that the police officer, not the defendant police officer, the alleged victim officer, if you will, is claiming essentially self-defense, that I had to shoot her because she tried to shoot me. All right. And that the other side of the coin is that she was potentially in a position of self-harm and whatnot. And one has to think that if the DA sought an indictment for attempted murder, that alleged victim police officer testified, she tried to kill me. She fired at me. She pointed at me, da 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 da, and whatever. And the grand jury said, for whatever reason, we're not even going to give you probable cause to believe that happened. I don't think that they would nullify and just say we feel bad because she got shot. We'll charge her for less in the event that they believed that this could have happened. Now, the other thing I find interesting is if the theory of the case is she pointed and literally, you know, has him in the crosshairs and even allegedly fired, something else is missing here. How did he not empty? I mean, if there is a gun pointed literally at a police officer, okay, and they're firing at you, then that police officer is 1,000% legally justified to aim what we call center mass, right? And just blast away until she goes down. And that didn't happen here. And nobody else fired either, which is interesting. Only because, you know, if you deal with these kinds of cases, if you have 3 cops and you see a woman in distress who appears to be having some kind of, you know, psychiatric episode or whatever, that all goes out the door. If she has a loaded gun, they know she's a police officer, and that gun is pointed and aiming and firing at a cop, she's going to be full of not one bullet, but potentially 10, 15, 20. So a lot of what's going on here doesn't seem to fit this theory of attempted murder, but that should have factored in certainly to anything involving bail. And then when you just take a mentally or somebody going through mental challenges, mental health challenge, or, you know, with postpartum depression and everything else, and, you know, they've taken your child away, you're facing all this, and you just lock her up after letting her out. I mean, finding that, you know, the whole purpose of bail is to set the least amount of conditions necessary to ensure that somebody returned to court, and in Massachusetts, to protect the public, which is interesting. Like in New York, that's not a factor, by the way. There is no dangerousness hearing. It doesn't exist in New York, but it's a real thing in federal court and Massachusetts. But it's just fascinating that apparently the scram test was sufficient to deem her not necessary to be jailed. But when it was brought to the court's attention that there might be some logistical issues, there are no positive tests, probation supports it, we're trying to figure this out, we'll get you the evidence, that upon not doing that, the judge decides all of a sudden this condition is no longer satisfactory, so away you go. And then when you got to today's decision, what did you see? Again, it was very hyper technical. They didn't they didn't bring this up this time. You didn't say this. You could have done this. You didn't do that. That's really getting ticky tack to kind of dig in, right? And really like get ready to brawl and hold your position, as opposed to say, my analysis was, I can't have her drinking. I need to make sure she's not drinking. That's part of my ruling on dangerousness. So come up with a solution somehow, some way, and do it. And she didn't want to do it once, you know, there was no solution apparently right away. They were trying to do this. And, you know, did the judge read what's been going on the last 3 or 4 days? I don't know. I'd like to think not. They shouldn't be influenced by this. But today's ruling appeared very defensive. It wasn't so unsound legally, but it just felt so defensive, so hyper technical, and so punitive, which I think is the worst part about all of this, is that, for the love of God, what are we talking about here? We're talking about, I don't want this lady to drink, because to me, that's a condition that has to be satisfied. And she wasn't interested in fashioning a solution with the parties. She was interested in saying, you didn't tell me this, you didn't tell me that, get the hell out of my courtroom, send her to jail.
Yeah, isn't that interesting? Because this is what I'm thinking. Everyone's bringing up in the chat. Amanda says the judge lied because Bradel extensively said, Bradel did bring up, and so did the probation officer. Amanda goes on and says the judge lied in the order. She said no one brought this stuff up before now. Not true because Bradel brought it up. He did bring it up, and in the order, the denial.
But
She's basically saying no options were offered. He didn't offer anything. He did offer some options,
she
and she
walked
did.
off.
She shut it down.
She walked off the bench, is my
Yeah,
understanding. So,
exactly.
but again, whether there's an agreement or disagreement about, you didn't bring this up or you did, who cares? I mean, there's a larger principle here, which is, am I really sending this woman to jail over this? Now, if you think she's lying and playing games and you can justify that, I get it. But whether it was brought up or not, you read what you saw today, and it is a hyper technical law school exam kind of opinion. It's just checking off, making arguments for the sake of making arguments instead of being judicious and judicial. That's what you want a judge to do. Um, this is it. The decision here, or the impact of the decision, is unjust. Everyone agreed that she was a proper candidate to be released under certain conditions. One of them was she can't drink alcohol. They're trying to work through that. There are other ways to work through it. They may not be ideal, but there are ways to do it. And to throw her back in jail over this, it just feels like, I mean, call it what it is, just another Massachusetts case that's going to be on the national radar and become probably the next national embarrassment that comes right back to Massachusetts. I mean, it's uncanny how many of these cases all come back to Massachusetts. It's insane almost. But you can't cannot blame the Norfolk DA for this. Let's be clear.
It's Essex. This is Essex County. I've been waiting for this because there's been some controversial cases up here. This is a new DA. Paul Tucker is a retired Salem police chief. Then he became a state rep, and now he's the DA. It's his first term. He was endorsed by the previous DA who left after decades. There were some issues with him, and it was a very close race. It was a district attorney that ran against him, and it was like way closer than I thought it would be. Like Tucker was the guy that was endorsed by the DA. So this is interesting to see in Essex County because I think there are a lot of problems in this district. There's been a lot of corruption up here too. I mean, it's just been like, a lot of congressmen and just a lot of corruption on the North Shore. When we were talking about this whole thing with what the judge wrote, the judge ruled, and what we actually saw Bradel say at the hearing, I know Bradel's brought up SJC. Obviously, he's going to appeal to the SJC or higher court on this. Will that affect the appeal? Because are they just going to listen to the judge on that? And just because the judge says nothing was offered, is that going to hurt them? Or can he throw it in there? Is like, how does that work with the tape and all that stuff?
Well, it's an interesting point because the decision does seem written again in a way where the thought process is, how do I write this to survive an appeal? And there is a general principle that any appellate court follows, although it's not necessarily the law, depending on the level of court in the state. And I don't want to get too legalese about this, but the general principle, and this is everywhere, is that a higher court will generally show deference to a lower court on factual findings unless there is what they call an abuse of discretion. Some appellate courts are not even allowed to take a different interpretation of the facts. So an appellate court can certainly rule on a lower court and say, you applied the law wrong, so therefore I can reverse on this. But there are situations where appellate courts can be a little hamstrung by factual findings that can't be disturbed, or there's no basis to disturb, which can severely impact the legal ruling if there are certain facts that are not credibly in dispute on appeal, if that makes any sense. That sounded like what the judge was doing. I offered you this, you didn't do this, I still give you a chance under this. I mean, look, this is a hell of a hill to die on, by the way. If you're a judge, if you're the DA or whomever, um, there's no reason for this woman to be in jail right now. I mean, that's the bottom line. And it's just another example of the system failing, which happens a lot there, apparently.
Now, this judge is also from North Andover. Apparently, she lives there. She's been there. It seems like her whole life. I, is there? You think there's anything there that they could kind of remove her from this
I,
case because maybe a conflict? Because I have a feeling, just the way she's acting, that there's something there. I just feel it
I mean,
because I was at that first hearing, and when she was acting up at that first hearing about the ankle bracelet too. And again, I looked at the DA's office; they had no issue. They had no issue with having the ankle bracelet taken off for a surgery. The probation officer didn't have an issue with it. It was this judge and the way she was talking, the tone of her voice. I feel like there's something personal here. I don't know what it is. I just
well,
wonder.
I don't know. I mean, judicial temperament is a thing that, can certainly lead to issues. The fact that she lives in the same town, that's not enough. I mean, it's interesting, but you would need more. The fact that the DA is a former police officer and the alleged victim here is a police officer, is another issue that's at least worth scratching your head. But the other problem is we're in Massachusetts, and maybe the wrong DA is looking into this. I mean, again, I hate to always move everyone to say, how do you do it in New York? But generally, when you have police shootings, a lot of times, if it's in the type of police department that works with that prosecutor, you can understand the problem. And New York has instituted a thing where the attorney general takes over police shootings instead of DA's offices. But the other thing is, these counties in Massachusetts are much smaller. Not that they're small per se, but Essex County, Massachusetts, it's not that big. So the prosecutor and the police departments, the likelihood that they're all going to know each other and work together and live in the same town and da 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 is much higher than in New York, or a place where you have a police department of 45,000 cops and whatever. But so there's all kinds of things here that just make you feel a little icky about this. But it's going to have to play itself out. But at least in the immediate future, it's not helpful that it's playing itself out with this woman in jail. I mean, I think that there's just no need for that, and I think it's a complete failure of the system to not fashion a solution here that just says we'll find a way for her to take an alcohol test and be done with this.
Now, the former Attorney General, Martha Coakley, who's also a former DA of Middlesex County, uh, she ran for Senate. She ran for governor. She's very well known in the state.
Of course.
She's one of the attorneys that Tim Bradl's working with for Kelsey. Do you think that do you think the judge notices that or even cares about that at all? Do you think she's like,
I mean, look, I think it's literally impossible not to take note that the lawyer sitting to the left of the other lawyer is a former attorney general of the state and a former district attorney, and as I recall, at least when I lived in Massachusetts, the largest county population wise in the whole state. Was a candidate for higher office, is a very well known attorney. That brings some degree of gravitas. It potentially brings some degree of public interest. But I mean, to the extent, does it mean anything? Well, clearly not, because the client is in jail.
I know it's shocking. I think Martha Coakley's getting a taste of what really goes on here in the Commonwealth. It's funny because yeah.
Yeah, I mean, look, you see how the sausage is made there, and it's not a pretty process.
And so it's at opposite political parties too. I would say so a little bit, or maybe I don't know about political parties because I don't think Bradle's really into politics too much, but I think maybe different viewpoints politically, maybe.
Mhm.
Uh, so there's a lot going on beyond this case too. I probably have some other questions to get back to this. If anyone has any questions in the chat about Kelsey too, definitely ask them. But there's been some things going on with Karen Reed as well
Yep.
that are kind of like this, and they involve your clients. So if anything you can't talk about, just you know the rule. You know what to do. But I'm just wondering because they're holding Karen Reed's phones, and it seems like they're trying to charge her again with Aiden. There, it already failed once. Is this like legit threat to her? Like
I mean,
what is
look,
going on?
this is not new. This is not something that, I mean, it's new, I guess, publicly. It's announced and whatever. But if you go back and read all kinds of filings over the past several weeks, months, even perhaps, and you look in the footnotes and you look in the corners, they've been alluding to this for some period of time. If they go after Karen and Aiden or some combination thereof for witness intimidation involving the Karen Reed murder case for which she's been acquitted, involving the witnesses that and they intend to, I mean, however crazy they want to do this, but put Karen, Aiden, myself, him, Alan, all these lawyers together and cross-examine all these witnesses with multiple rounds of cross-examination. They've got to be crazy. And I mean, first of all, that's assuming they were to even get an indictment, but this has to be the most delusional thought process and effort by a prosecutor I think I've ever heard of, to literally, assuming they could indict the ham sandwich, to put all of those aforementioned people in the same courtroom and say, have at it, and call the witnesses who they'll be, to talk about whether they were intimidated in a case where this woman was acquitted for murder. This man brought it to everyone's attention, and these witnesses have been accused, in legal filings and other things, and generally not believed and made many false statements and other things to prove what point. But this is what Norfolk County is. And, I mean, this is just, look, I'll believe it when I see it. Again, I mean, everybody has to take them at face value when they say it, but this is a level of delusion of prosecutorial discretion that, take the loss, man, and move on. Okay. The murder case didn't go well. Let it go, be done. I mean, I think all these witness intimidation charges obviously ought to be dismissed for a lot of reasons. And, maybe you'll read about that in the near future. We'll see. But if they're dead serious about this, and that's why they're holding the phones to do this, but my God, is this going? I mean, look, you've seen a lot of crazy things in that county. You've seen war declared on rubber duckies. You've seen all kinds of just general craziness. This would be next level crazy in my view. But, we'll have to wait and see what they do. And if they do it and we're part of it, then, okay.
Seems like you might have some fun with it if it happens. I mean, you don't want it to happen, but
Never
it seems
fun.
like it might be a little bit fun.
Well, clients' lives are at risk. If they get indicted, it's not fun. But in terms of the blood sport component, to say, are we seriously doing this? I mean, just as a legal exercise, let's just say it's very motivating. The batteries get charged, and you're ready to expose what needs to be exposed.
Marcia had a great question here. Marcia says, can a judge make them stop going to grand jury? Is that possible?
Once again, welcome to Massachusetts, where they just do things. Apparently in Massachusetts, when you go to a grand jury and you come up short, you get a mulligan. You just go back. Now, again, I'm learning more and more how Massachusetts works. When I heard that, when I was told that, I didn't believe it. So that can't possibly be. New York and most other places, sane and otherwise, if you go to a grand jury and they return or don't return, they issue a no true bill, no indictment, it's over. And if you want to go back to the grand jury, you have to petition a judge and argue specific reasons why you ought to be allowed to do it. There's evidence that was newly discovered, or this or that. Okay. Karen's cell phones that have been sitting in their possession, gathering cobwebs for 2 years, is not newly discovered evidence. That's not a reason. This would fail in most other places. But in Massachusetts, the law is, you just take it to another grand jury. It's disgraceful. It's their criminal justice system is so out of whack with the norms of other places and with consideration of due process, which is stunning, because you would think that the Massachusetts criminal justice system would be so far skewed for defendants' rights, just based politically, and the kind of people who usually slot up with the rights of defendants and whatnot. And it's the exact opposite. And the whole purpose.
That's the funniest thing.
But let me just say, the whole purpose of a grand jury is to even though grand juries indict everyone except Karen and Aiden the first time, right? Is a check on government abuse. In other words, we're not going to just let the government say we're charging you with a crime. You're going to have to get a grand jury of citizens to say, well, there's at least probable cause, and we're not even going to make the judge be there. We're not going to let the defendant be there. The defense attorney won't be there. There's no argument. We're going to make it real simple, but it's still a form of check. Okay. And so they went to a grand jury in March of 24 to seek to indict the two of them together. And I know that the timing of that first grand jury was disgusting. Okay. That was right before Karen's first trial. And that you and I and everyone else watching knows why they did it. Number one, to try to have her bail revoked and lock her up. And number two, to get the press hit during jury selection or whatnot, that not only is she, a murderer, but she's a witness intimidating scumbag too. That's what that was. Okay. But nevertheless, they do it. They get punted by the grand jury. That they've checked the government. Okay. They've said no dice. Now they say, well, we'll go back and now we'll try to get in her phones. We had the phones the first time. We apparently didn't make enough or a successful effort to get in. Now you should let us get in, do these things, and do it again. That even if they do that, again, is a grand jury going to do this? We're here on the case of, the Commonwealth of Massachusetts versus, Karen Reed and or Aiden Carney, right? Can you imagine? I mean, half the grand jury looking around saying, when is enough? Leave this woman alone. Enough, right? Enough. And, her civil suit presumably will be going on, whether it's as a defendant or a plaintiff, who knows? This is just mind-bogglingly stupid for them to do this, if that's really what they're doing. But they have the legal right to do it. So, and they're not bashful, and they're not so much concerned about the public perception, and apparently have very little concern or regard for the fact that there is a crisis of confidence in that whole county's law enforcement system. You may hear a little bit more about that soon too. But the point is, nobody has any confidence or faith in how they do things there. And when they start talking about going back to the grand jury and indicting someone acquitted of murder twice, actually, and saying, but she intimidated witnesses, we think, because she might have had conversations with this other guy who, we think he intimidated witnesses. So let's send her to jail for that. I mean, this doesn't even feel like America at this point. This feels like just a complete and absolute joke.
Yeah, it absolutely is. It's funny when you mentioned institutional, I feel like the rights go out the window when institutions need to get protected in Massachusetts. Like the bigger thing, everyone thinks we're so liberal, we're this or that. It's like we're parochial. We protect the institutions. That's what it's about. Institutional power.
That's the hackerama. Yeah, I mean that's what
the hackerama. Yeah, the hackerama. That's what Howie calls it, right? I mean that's what it is. It's just there's a real big feel of that in Massachusetts. You scratch my back, I scratch your back. It goes back generations. I mean, that's how the whole thing started with the Kennedys and the Irish, and it just hasn't changed. It's the same thing over and over again.
Again,
Um,
I'll believe it when I see it, but I don't. I mean, I don't think they're making it up. I don't believe that. Uh, Robert Cosgrove writes motions and just drops footnotes and says things that he's making up. I don't think he's like that. I question the judgment and what you're doing or what you're thinking about, but I take it seriously. I don't. He's not lying.
this comment too that I like says, Mark, they are after dirt on Turtle Boy and for the O'Keefe civil case, in my opinion. Do you think there's an element of that? Do you think they're trying to help the O'Keefes with the civil case, and they want Karen maybe to dish some dirt on Turtle Boy? Maybe is there an angle there? Maybe.
Listen, I'm not going to get into the two
Motive.
clients.
Yeah.
We're not going down that path again. We saw how they tried to exploit that the first time. At before Karen's second trial. But if the DA's office, which has an obligation to serve the public, right, and to bring forth ethical and proper and just prosecutions, is abusing the grand jury system and abusing and exploiting the criminal law to help people that they sympathize with in a civil proceeding, then they should all be fired today, tomorrow, yesterday, and face additional penalties. I don't want to believe that's true. It's an interesting theory. I'm not going to say that it is true, but it couldn't be more inappropriate for the district attorney's office to allow itself to be exploited by civilians to further their interest. Having said that, you might read a little bit more about that too in the next few days.
Giving some hints. What's going on? Anything else?
No, it's just
No.
we're on topic, so it's
On topic. Yes. You're working on this. We mentioned this earlier. This mega motion for
that's not
Aiden.
my word. It's definitely not my word. We're writing motions. That's what
Yeah, that's
lawyers
what Aiden. That's what Aiden called it. Okay,
call it.
but
It's
that big
very
motion that you're writing is that how many pages? Like, can you give us an idea? Is it like 10 pages, 20 pages, 30? Like, any idea on that?
a lot more than that. That's
A
all
lot
I'll
more
say.
than that. So this is a lot of work for you. I can
It's
imagine. How
um
many pages like do you write like in like an hour? Like is it like 5 pages, 1 page?
and
Like how?
I,
'Cause
it's I mean it depends how you're doing. I mean, look, there are different ways. I'm speaking generally now. Okay, I'm not talking about the merits. There are different ways to do things. I having seen a lot of the normal practice of how motions are filed in Massachusetts. What I can simply tell you is that stylistically, this has a lot more New York feel to it than the way generally it's done in Massachusetts. In other words, um, in New York, motions are generally made by affidavit, sworn statements, actually alleging facts, sourcing said facts, explaining where those sources come from, providing copies of sources, and then filing a second document, which is a legal brief, what lawyers call a memorandum of law, briefing what the legal issues are and referring to the factual statements and evidence in the affidavit. That's how this will be done.
people here. I saw Kelly Reed in the chat. How you doing, Kelly? Did you see her the other night? I think you even hung out with
We
her,
had
didn't you?
dinner beforehand, yeah, before and went there together along with a few other people. Yeah, everybody had a great time. Went to the casino after. I'd never been there before, by the way. I'd never been to
Never
the
been there. The Encore, right? The
huge.
Encore Everett Casino.
No, I mean it's interesting. I guess don't let all the Massachusetts people go to Mohegan Sun and Foxwoods or whatever. It's right there. So
Alicia says, "Does this harassment quotation marks help Karen Reed civil case, the one that is supposedly to be filed Would it help her case if she sues with what they're doing to her right now?
I mean, look, you know, it's not a good look to be coming after her. I mean, I've used this analogy before, but they have, for the better part of 3.5 years, treated Karen Reed like Moby Dick, and Michael Morrissey is like Captain Ahab, chasing her around, looking to harpoon her. I mean, she's become the great white whale, and this is the hill that that office is apparently willing to die on. It's they're willing to dedicate what did I see online? The amount of budget resources percentage wise. By the way, that in and of itself is a reason to throw him out of office politically. I mean, if you're running for office, I mean, the allocation of resources is that was awful. But yeah, I mean, the more she's victimized and they go after her, that can only help. There's other things though that can help too. I was acquitted twice, probably. Um, that's going to help. She almost certainly is going to be filing a civil lawsuit. The other advantage she has, as you know from the first trial, the second trial, and not, is that she has really good lawyers who know how to play this game. And to me, not that I'm in the business of giving anyone in the Norfolk DA's office any professional advice or public relations advice, but the best thing they could do is turn heel, go in the other direction, and walk away from all things related Karen Reed. She's like the third rail to them. Forget it. It's over. And if the O'Keefes want to sue her, they have every legal right to do it. I don't think it's a very good lawsuit for a lot of reasons, the least of which is it's tough to sue someone for causing someone's death when there's no credible evidence that that person, even who was driving a car earlier that night, made any impact with, the person whose death you allegedly caused. I mean, I don't think you have to be a legal scholar or even a fifth grader to understand that concept. So I don't know why any of this is happening, but yeah, I think the more they go after her, the better it can be potentially helpful for her. And I think at this point, I mean, what her mettle is. She's not going to cave to this. I mean, this is like a walk in the park for what she's been through for the last 3 years or whatever it is.
But, it's funny when you say that about Karen because it reminds me of Kelsey too. I asked her father about that, and she's not taking it. Like Kelsey is
Well,
not going to take this. It sounds a lot
the
like Karen in a way.
circumstances are very different for a lot of
Definitely.
reasons. Number one, Fitzsimmons is not facing consequences like Karen was, meaning, you could theoretically go to prison for 20 years or
20
more.
years.
On the other hand, Karen was never in jail. Not really. I mean, I don't mean booking and all that. And, Fitzsimmons is literally caged in a warehouse right now. As a postpartum young mother whose child was ripped away from her, as a police officer, which can be very tough. I mean, she'll be protected, isolated, all of that, but that can be more difficult too. So I think they're very, very difficult and different situations. But I mean, I don't know anything about her mettle or personality, but I have a strong feeling that she'll be pretty tough, and eventually she'll get out of jail and fight and whatnot. And I have no doubt that the legal team they've assembled, some of which I've seen firsthand, as you know, very close, will fight like hell and get where they need to get, and hopefully get a happy ending if that's what ought to happen here.
So, we were just talking about the Karen Reed civil case, the one that the O'Keefe family has filed against Karen. I just wonder how that works out, like you said, because they have to prove Karen did it. They couldn't do it in criminal. You think they're going to bring out the same witnesses? Like, are they going to hire Aperture to show up, or like,
Well,
how do they do that? How do they do that if you're trying to prove Karen did it when you're the O'Keefe family and their lawyers?
well, it's a little different. I mean, it's not like they have to prove what she did other than make impact and cause his death because of the alcohol and being overserved, and that's how you drag the bars in. But, in the civil lawsuit, of course, the principal difference is the burden of proof is much less. That's true. The burden, we're not talking proof beyond a reasonable doubt is out the door, right? We're no longer talking about that. But the reality is this. You asked about aperture. They have to be out of their mind to let those people within 100 yards of a courthouse anywhere in Massachusetts after that fiasco. So I doubt they won't. But the point is this. At Karen's criminal trial, the defense, as you know, they don't have to prove anything. Now, turns out on the issue of whether there was any kind of vehicular strike with John O'Keefe, although they had no burden and all they had to do was poke reasonable doubt holes, I would suggest to you that based upon the evidence they presented in the form of 3 medical examiners, a neurologist, I believe, from the other side, 2 engineers, so that's 5 to 6 medical or other doctor types, pretty much established, even though they didn't have to, right? All they had to do was poke holes. But so it's not a legal exercise, but as a practical point, they kind of probably proved beyond a reasonable doubt that there was no strike between John O'Keefe and Karen's vehicle. Now, so even though the standard of proof is much less at the civil trial and it's a different jury and different this, what are the benefits that Karen gets going to the civil trial? Well, number one, she's acquitted and everybody knows it. Everyone hearing that civil case is going to say she didn't do it, or that's what 2 juries said anyway. So, that's the first thing. And the second thing is, how are they proving the causation element? Any civil lawsuit in any criminal case, you have to prove causation. You can't just prove that Karen was driving while intoxicated. That's proven. She's convicted of that. That's literally easily, you can prove that with, court documents that you certified. You can move into evidence to establish that. But putting aside that and putting aside whether she was overserved and putting aside whether all the witnesses against her are actually going to say she did not appear intoxicated, they were as much or more intoxicated as her, none of that matters because there's no proof of an impact. So how could she cause his death? You can't blame her for saying, well, she dropped him off and left. So then he just, either she hit him, a plow hit him, or something happened. So it's her fault.
Not her fault. Yeah. Yeah. No way.
I mean, look, people may feel differently about this. I mean, I always have a lot of sympathy for the families of people who die or who believe that, their loved one was murdered or killed in a criminal way. But I think it's unfortunate in this case. I think the O'Keefe's got a lot of bad legal advice. I think they got a lot of bad hopes and expectations from the DA's office and the state police. I think they got a lot of bad advice from people that they assumed, were friendly with them, who may have been looking out for their own interest in that whole situation. And, so here we are. But I suspect when that lawsuit is litigated, they're going to have an equally disappointing result. At least as it relates to Karen. I mean, the bars, if they want to throw a few dollars to go away and they settle it, that happens all the time. Even though the liability against them, I think, is not great either. But putting all that aside, it's not inconceivable. The bar just takes the pragmatic approach. It says, this isn't worth it. Take this and let us out of this, and you guys go fight to the death in court.
Question: if Karen wins the civil suit, again, that as a defendant, and she defeats it, does she get her legal fees back? Can she ask for those back from the O'Keefes or not?
In a lot of civil litigation, the losing side can definitely be forced to pay the winning side's legal fees. Not, again, an expert on Massachusetts civil procedure, but that may very well be a possibility. And the reason that those laws or policies or court rules, whatever you want to call it, are in place is you want to disincentivize people from filing frivolous litigation. And the way you do that is saying you better win or else. Now, I'm not saying that the O'Keefes are filing frivolous litigation. I'm saying it feels like losing litigation. I mean, I think they believe what they allege. I just think it's, it's off base, but I think they sincerely believe it.
You think a judge would balk at that just because of who they are? Like in terms of, I'd feel bad. Like I mean, I think Karen probably does deserve her fees
Well,
back if she wins, but I would still feel bad for the
well,
O'Keefes. I wonder
people,
if a judge would consider that.
well, you shouldn't. I mean, the people you
Yeah,
blame
no
would be
sympathy.
the O'Keefe's lawyers and the bad advice. And if things happen, it opens up other avenues to people then start suing their own lawyers for, malpractice. You told me this was a winner and you told me this, and it turns out it's like head first into a brick wall without a helmet, and now they're coming after us. So this is not my bag, right? This kind of stuff generally.
A little off track for you.
Yeah, I mean, to be honest with you, I don't even find this lawsuit all that interesting. I mean, other than the people involved, it's very interesting.
Sure.
But I mean, as a legal exercise, I don't think this is a very captivating case.
Too much about it. That's why I'm asking you a lot of questions tonight on it, because I really haven't discussed it. Tara Ellis has a question. This is a big one. If they do indict Karen, will they arrest her on these new charges? And I want to add that for Aiden too. Like if they indicted them both.
I would hope that if that were to happen for either one of them, or anyone, in a situation like this, where you're not talking about a public safety situation, you're talking about people or person anyway who is aware of being under investigation, who has never demonstrated any flight risk or anything like that, that in the event something happens, that this would be done in what lawyers call the civilized way, an arranged surrender, if it comes to that. And what real lawyers do is reach out and negotiate to say, if you tell us something happened, then we'll march in and deal with it. It would be very regrettable if they were to send a bunch of stormtroopers banging on doors, perp walking and all of that. I mean, I think that would be another misjudgment. I'm not saying they would do that, by the way, but they could. I mean, they could, sure, they could just go arrest them. They could.
Would be uncivilized because these are two people who always show up for court. They're always there. They've never had any issues with being on time and being where they're supposed to, and they abide by the court. So it shouldn't be needed, right?
It shouldn't be needed, nor would bail. I mean, again, there's no dangerousness here. There's no flight risk. There's no anything. But again, I mean, we're all getting ahead of ourselves too.
I know. Let's hope it doesn't happen.
There was an article published. There was a motion that apparently was, publicly released about why you don't get your phones back, which I'm not sure I understand either. I mean, those phones should have been imaged 2 years ago, whenever they took them. And I mean, I know we've talked about this before, I'm sure. But if the phones, I mean, we've seen it in the other case with, my guy's case. If the phones themselves have no evidentiary value, I mean, the instrument of the phone, like it's not important, just the data within it. There's no reason to keep it. You extract it. The lawyers will often call a mirror image. You have it captured as it existed at that time, and you give it back. That's not how they do it, apparently, in Norfolk County, at least as it relates to matters involving, the people that we're discussing tonight.
Question: If those indictments ever came down, would it be Canoni again? Would we have to see Judge Bev again?
Well, maybe that'll influence them not to indict another person with Karen, because I would say no way in that situation. I mean, look, again, they just do things different in Massachusetts. The judges, they rotate in and out by county. It's not what I'm used to. I'm used to judges are in a certain county, and that's just, the bench in any county, and it's like roll the dice in Massachusetts. I suppose it's possible, depending on who's at the defense table, right?
Someone said she was transferred to Plymouth County anyway, so maybe.
Yeah, but they all get transferred, but they all come back.
They come back. Yeah, they come back.
I don't understand the method to the madness. I mean, the way Massachusetts, and this is not a criticism of the judges themselves, it's I just don't understand the system. But I mean, it feels like, you know, in the days of Abraham Lincoln, where the lawyers would travel the circuit, right? And they would just bounce around and do this. And I've never really seen a situation where in a large state with a lot of judges in a lot of counties that they just bounce around and go here and there. And it's, you know, it used to be the purpose of having counties is it's a legal jurisdiction. You know, it's for courts and things like that. But not really in Massachusetts. The county lines mean nothing in terms of, you know, other than the DA, I guess.
Question for Mark: why can't we find Cosgrove motion under any docket? How was it filed other than being released by mainstream media?
I don't know. I mean, I saw a reference to it online like everyone else. So I don't even know which docket it came from, frankly. You know, I've had my nose in other things for, you know, several weeks. I obviously follow the news and developments, but, you know, other than what I saw reported and a couple of what I thought interesting footnotes in the motion about, you know, search terms and who should not be exempt and who should in terms of, you know, legal issues that might attach to restricting scopes of searches. I mean, I found that interesting, but other than that, I don't know much about it.
Question out of left field. Lettuce says, Mike, I would like to know how Mr. Bederow feels about some of Luigi, what is it, Mangione or something? Yeah, charges were dismissed today.
My response to that is I told you so. I wrote a guest essay for the New York Times in December. They were asking me about the state terror charges. And I said in nicer language than we're having right now, that the state terrorism charges against him are an absolute joke. That's not what the terrorism statute in New York, which was enacted, by the way, on September 13th, 2001. I wonder why, right? That's not what this guy did. And I'm not a fan of this guy. So I don't want to get into these lunatics outside the courthouse celebrating like they won the Super Bowl because, you know, a count was dismissed. I hate to say it to people, but this guy is going to either die in federal prison or get a worse penalty.
He's going to get fried.
Well, I don't believe
penalty.
I believe it'll be life in prison.
They don't do many actual federal death penalty, even though it's an option.
The Justice Department is a very different place today than it was a few years ago. But anyway, that's just the way it is. But the state case against him was always overcharged. And in New York, most states would call first-degree murder what you think, like this guy did. This was very methodical, plotted, planned out, as premeditated gets. And if you live in New York City, this hits you a little differently, okay? This was a shooting in the Christmas season, which, as you know, in New York is crazy, on 7th Avenue and 55th Street or something like that. That is the absolute heart of Midtown Manhattan, okay? That's a block or two from my office. But it is the absolute, like, heart
center
now Manhattan, and here comes a lunatic that just walks up to a guy and not for nothing blasts him in the back. I mean, it's a real gutless shooting on top of everything else. But in New York, that's murder too. It is what it is. It's a 25 to life. It's not a first-degree murder. It's not a terroristic act that's going to get him life in prison. But the issue, and this is for a lot of reasons. So the state, if the terrorism charge was allowed to stick, you would be inviting this guy and his lawyers, who I know, and they're good lawyers, but you would be inviting the soapbox because you're inviting an argument that this is not done in furtherance of terrorism. It's because of, you know, a manifesto and screaming and yelling about how much I hate the healthcare executives. And you're talking about a Manhattan jury pool, which, by the way, when you see like the people who are jumping up and down wearing Luigi from Super Mario Brothers outfits and making general fools of themselves, welcome to New York. I mean, that's, you know, it's It's not that weird here. Very liberal jury pool, very sympathetic. State court rules of evidence, much more sympathetic. The penalties are less. So many different reasons not to do it. And then you go to the feds and you say, all the feds have to prove is that this guy took a loaded gun in interstate commerce, which in English just means from state A to state B, with the intent to use it, used it, and somebody died. In other words, it's just like a regular murder. No terrorism, no nothing. You get a much better jury pool. A federal court jury pool includes Westchester County, which, if you know people familiar with New York,
rich suburbs.
That's right. I mean, not what I would call,
the people who are going to be like, fry this guy.
I mean, as far as New York goes, that's as conservative for juries, at least in New York City. Well, maybe Staten Island, but putting that aside, better rules of evidence. They're going to get a better jury pool. All the evidence of this guy's, why he did it, irrelevant. But the most important thing you have are the penalties. The leverage that the U.S. attorney has is the highest leverage that exists in criminal law, death. And what's ultimately, I think, going to happen here is they'll offer him a deal. Then the deal is you die in prison forever, and we take the death penalty off the table. And that's that. And the reality is, whatever you think of his motives or, you sympathize, the evidence against him is pretty overwhelming in terms of bringing a loaded gun across state lines and using it and da-da-da-da-da. So the state case is meaningless anyway, and there's all kinds of politics here, okay? Who's the head of the Justice Department? Donald Trump. Who's the Manhattan DA? Alvin Bragg. What did Alvin Bragg try to do to Donald Trump a year and a half or 2 years ago? He tried him. Remember they had that trial, the Stormy Daniels nonsense. Of all the things, that was one that was really probably didn't belong in the courtroom.
Yeah, that's kind of iffy. That was an iffy one. Because I get it, because it is BS. They shouldn't be doing that with, but still, it was
a misdemeanor that they bootstrapped and only to beat the statute of limitations. I won't get into that. But the point is, there's political components to this. But at the end of the day, whenever there's a power struggle between a local prosecutor and the Southern District of New York, which is, the most exclusive prosecutor's office, certainly in the federal system in America, the sovereign district, they call them, that's what they're called, of New York, they're going to win. The Justice Department is going to win. He's going to be dealt with in federal court. But when he first got arrested, I did write that piece in December in the New York Times saying this is ridiculous. It's a bogus charge. It's a stupid charge. It's never going to hold up, things to that effect. And I'm not at all surprised it was dismissed. The judge, who has been around a long time, Greg Caro, very smart judge. So definitely, if you have a good legal argument, that's the kind of judge you want to be in front of. But again, it's all lipstick on a pig for the defense. He's screwed in federal court, and this is all meaningless nonsense in the grand scheme of what's going to happen to him.
And Trump campaign violations and just got a fine. I know, and other people went to jail for her, which is, we're not going to get into politics tonight, but it is funny. It is funny how Hillary, nothing happened to her, but other people that she enlisted went to jail.
I'm not talking about Hillary Clinton.
I know we're not going to get into that.
I'm definitely not talking about Hillary Clinton.
I'm trying to be fair to everybody because I get accused of being biased. Of course, everyone has a little bias. Come on.
I'm not talking.
We don't really talk about it. Yeah, Mark doesn't want to talk about it. I love it. I like Mark. Mark keeps me good on here when he's here. Keeps me from getting in trouble. When Mark's here, I stay out of trouble. I got a question about Juna Perkins is running for district attorney, and she took a little heat on this, but I kind of liked her answer on this. She basically brought up the fact that, I asked her a question. The question was, will the McAlberts ever, what would you do? What will you do about John O'Keefe? If you win as DA, what will you do? Will you do anything about it? Will anyone be charged for this? And she came back and said, no, no one will ever be charged for this on a district attorney level unless like a lot of great new evidence appears. Because number one, there wasn't a good investigation, not a lot of good evidence. And number two, because if she were to ever try, let's say, Higgins, he's going to turn around and say Karen Reed did it. And it's going to be a good defense for him. And it'd be really hard to convict someone for that. Is she right? Do you agree with her? Do you have any issues with it?
I mean,
what would you say about that?
I have an opinion about answering the question about whether anything will happen, and then I have an answer about her answer. I think her answer is poorly formed. She should have been, I think, a little more political and just punted more and said, I'm not privy to what went in the office. I'm privy to what's in the news. And if I'm the DA and there's evidence that I'm allowed to look at and those sort of things, and I would look at that. If there is any possibility of a good faith basis to investigate, I will do that. But it would be inappropriate to literally say I will or I won't. I mean, how could she know? I mean, without even knowing. On the other hand,
I gotta add. She did mention that. She did say that part that
okay.
some of what you said. I think she was more like just saying the fact that it just wouldn't make sense to unless a lot of new evidence came out. But I definitely
I don't like that answer, to be honest with you.
Yeah.
I just say when I am privy to what it is. And at the same time, I would add to that answer. Meanwhile, I'm not obtuse about what I saw in the Karen Reed trial, and it raises major problems. And then I would get into some of the problems, the relationship between the state police. I won't have that. I mean, I thought, you turn it into a, your own narrative. As far as the merits of what she's trying to say, I just think not perhaps in the best way, but I get the point. The odds of anyone ever being prosecuted for John O'Keefe's death, whether it's murder or otherwise, are almost nil, barring evidence that we can't comprehend coming to light. And the reality is, what is everyone's defense going to be? Karen Reed did it. You want to talk about a third culprit defense? That would be the defense, and it would be allowed. I mean, it would be an appropriate legal defense, even though I don't agree with the merits of it. I mean, I think she got railroaded and framed, 100%. But this case was so screwed up, so many things went wrong that, one of the unfortunate things is that not only did they put her through hell for 2.5 to 3 years, but they pretty much, barring a miracle, ensured no one else who may in fact be responsible ever gets the same treatment.
It's tough. I mean, that's a tough answer. It's hard to hear because Kyle's got a question. Mark, with what you have seen with Proctor's text, does it surprise you in the least that Mr. or Ms. Beatty is representing to Judge Krupp that there is exculpatory material in the federal? So I got it. Okay. I wasn't sure where that question was going. What do you think about that?
Well, in all fairness, I've seen a lot of Proctor texts that none of you have, which I can't talk about the substance because of all kinds of legal orders. But in that context, am I surprised in the least that the DA is saying? Not at all. Of course not. The guy is a disaster and a train wreck. Okay. You've seen a lot of it. It fits. No, I mean, why would anybody, do you think he only talks about Karen Reed? I mean, do you think that's the only case where he acts inappropriately? And let's also remember that when we talk about exculpatory evidence, what are we talking about? You're talking about evidence which favors the defense. And there are really multiple components of that. It can favor the defendant in terms of substantively help you demonstrate you didn't commit the crime, something that proves it didn't happen or would suggest that, or adverse credibility issues, right? That's Giglio material. Well, it's part of Brady, but lawyers call Giglio material. And so I don't think it should shock anyone that, there might be 8,000 pounds of Giglio material about Michael Proctor all over the place, right? You've seen the things he says and does.
Yeah.
He is a walking Brady violation, it feels like.
So do you think we're going to get to see a lot more of this stuff?
Yeah,
And
yeah. I
when
mean,
and where?
eventually. I mean, look. Eventually. I mean, just given the cases that are going on now. I mean, if we get tried at some point, in any of these witness intimidation indictments, of which there are really three separate cases for now, um, a lot of the stuff will come out. I mean, that, stuff that is held under a protective order or under impoundment or whatever, takes a back seat to a defendant's fundamental right to a fair and open trial, right? And to use evidence that helps the defense. And there's a lot of evidence that is not available to the public that we can't discuss that helps the defense. And we will use it if they try us. That's just the way America works. So, that's up to them.
Cake invasion. They're all coming over. I want to thank Melanie Little for sending people over. I know she just reviewed the new ruling from Kelsey, and all the cupcakes are here. They're so funny. I love when that happens, Bederow. Do you like cupcakes? Are you a big cupcake fan?
Um, yeah, I do. I mean, I don't eat a
I
lot
love
of like
cupcakes.
super sweet food,
I
and
do.
I'm
I'm ridiculous.
also I'm going into a little bit. I'm going into a health lockdown. Periodically we do this, right? You just
Lockdown.
go through, except for steak and things like that. When I go to Massachusetts, I tend to end up at the steakhouses. Short of that, though, I'm no sweets right now.
No sweets? What are you giving up? Like, is this like Lent or something? I could never do that.
No,
Like,
no,
what
no,
what what
just
are the sweets you're giving up? What kind of stuff do you
certainly no.
normally, if you weren't?
Well, the good news is I'm not really a sweets person, but no bread stuff, no, lots of lean proteins, right? Greens, things like that. A lot of water, bland food, oatmeal.
Oh,
I'm on lockdown.
I mean, I drink a lot of water. I like the water, and I will do some greens. And I got the green beans, upstairs right now. But
Not big
I
on
gotta have
green
the
beans.
sweets. I gotta have the sweets, man. Like I'm I probably spend like $25-$30 just on Reese's peanut butter cups a week. I mean, I'm ridiculous. My
Oh, there might
girlfriend hates me. She hates me.
if you'll be flying off the walls if you eat $30 of Reese's in one night.
I do. I love chocolate. I'm just like
Now my vice is coffee, and
there you go.
I,
That too. There you go.
yeah, and the last few weeks too. I mean I've been just way over caffeinated, but that's
You work. Do
it's
you
lawyer.
would you make like the pot of coffee? I like the pot of coffee, but we've gone to the Nespresso. We have two of them, two Nespresso machines.
We do
Some people
both.
do the K cups. What do? You do both?
We have an espresso machine, which I like, and we have a mocha master, which is a very high
Ooh,
end coffee,
yeah.
traditional coffee. But lately, with the when you go into heavy writing mode and those kinds of things, I'm a morning person, so I'll get up early and stop early. I'd rather, but it's not inconceivable that I'll start at like 4:30. So that Nespresso is not working and is not economically feasible either when you're literally popping in one after the other. So
That's what I tell my girlfriend. I said, you know how much money I'm spending on because I'm the one
oh
like
my God, those
she
things
does
are
like one a day, and I'm like doing two, three, four, and she's like, you better order triple.
oh no. If I'm gonna have, I mean, I'm having four of those in like one sitting. So we're
Yeah, I know, right? You're
making
like
pots.
me.
But even that, like, so I mean, I'm a coffee snob, so I grind. I
So
don't buy.
I love grind. Yeah.
Yeah, out.
You're
People
hardcore. You're like me. I love
very,
it. I love
I take my
coffee.
coffee very seriously. I don't think people
Me
around
too.
here are pretty thrilled when the coffee grinder starts screaming at 4:30 for, and if you're making a whole pot, you're talking 7 or 8 scoops. That's a good 30-second. So
Wow.
uh,
Yeah, someone said, "How do I stay so thin?" It's genetics. Everyone in my family is skinny. It's like ridiculous. And like, what do I do all day? I'm walking dogs too. That's the other thing. I have
exercise.
genetics and I walk dogs all day. Um, yeah, you know what? There were some other definitely some other questions. Actually, I want to play the video. Have you listened to the video? Have you listened to the audio? You haven't listened for
Um,
Kelsey yet
I've
of
gotten
that?
descriptions of it.
Okay.
I have not literally listened to it.
Okay. Because I would you mind sticking around? We listen to it a little bit, and you can
Sure.
raise your hand anytime you want me to stop it and
Go
maybe
ahead.
make some
Just
points on it. Because I think it'd be good for to have you listen to it and see what you think about it. Because I this kind of set the world on fire when this audio came out. I
yeah.
reported on it before the audio came out, but when the audio came out, people went crazy. Um, I just wondered, do you think this is good for her? It sucks that she's in jail, but I think it's good that there's a lot more attention on it now because of what this judge has done. Does that really make a difference, or am I just being too hopeful?
There's a lot more attention on what was that?
Well, the fact that because the judge made such a, kind of a poor ruling and her tone and the audio came out, that it brings a lot more attention to the Kelsey case. Is that really helpful or not, do you think? Like,
Well, I
because I feel
think
like a lot more people are going to show up now for it.
well, yeah, I think any time that there is a public perception of injustice or unfair treatment, that naturally will increase the attention of people. And then the case also has other interesting components that not every case has. I mean, you have a police officer who shot another police officer. That's interesting. The defendant in this case is a young female. That's not common. That makes it more interesting, just in general. It's a high profile thing, but when you do get a decision, which at least on the surface doesn't appear to make a hell of a lot of sense, putting the law aside, just about why is she in jail over this ticky tack stuff. Yeah, I think it's going to create and it's going to rally troops. And I think, unfortunately for the judge and prosecution, the timing couldn't be any worse because there's already this organized, hangover, if you will, from all the Karen stuff, thousands and thousands of people that are amassed, which definitely it transfers easily. It doesn't hurt that the lawyers are Tim, who's very well known and whose other client brings a lot of attention to other things, along with an attorney general, a former attorney general. So there's a lot of elements of things, a perfect storm, if you will, to bring this together. But you add in the injustice component, what seems to be, and it's just a perfect storm for getting public attention. And I'm sure at the time this case first started, the perception was that anybody who shows up to court is going to be her family and maybe, some cops who are just there for support, more for, the alleged victim in the case. And now what they've done is they've rallied the troops. And I'm not going to be there, obviously, but I imagine that they're going to pack the courtroom like they did for Karen and Aiden and all of that. And here it comes, here comes the wave. And I'm sure it's not what they thought was coming, but it sounds like it's coming and it sounds like it's growing.
It is, and it won't be pink shirts this time. It's going to be purple shirts. Kelsey's favorite color, we found out from her father, is actually red, but they've decided to suggest purple if people want to show their support for Kelsey, because that is the baby's birthstone color. So if people want to show up, it's not pink this time; it'll be purple. Yeah, this is a couple things about North Andover Police. I've started looking into them. Two female police officers in the last, so many years have filed lawsuits against the North Andover Police for, you know, the usual sexual harassment and discrimination. I mean, to me, I'm looking at it. This is the third female police officer that's had issues with the North Andover Police Department and this chief. Do you think that's going to get brought up in her defense? Do you think that's to put them on trial? Because I feel like that could be an issue here for them.
I don't know, but it doesn't sound relevant. I mean, this is a situation where the cops were called over some family squabble or whatnot. And, the facts are not 100% clear in terms of there is some degree of disagreement, but, I don't think it's there's a factual dispute that she had her firearm, whether it was to her head and the cops, and he shot her. I mean, I don't think that has anything to do with her, I mean, being a woman. The larger question about her being a woman is the apparent lack of empathy and I think discretion in what's going on, about recognizing the postpartum issue, which can definitely factor into this. And, you know, these cases can be complicated. It's not open and shut. Even if they're arguing over the facts, there are other things going on here that ought to factor in. And when you have a young mother dealing with terrible family fighting, and there's a young kid, almost a newborn, I think, stuck in the middle of it, and you factor in the postpartum stuff. I mean, there's a lot going on here, and this is a lot more nuanced and complicated than a DA charging her with attempted murder, which clearly there are problems with this case because that charge got blown out like right away. I mean, that's rare. That is very rare.
Actually, for that type of charge, yeah. Right?
Yep.
There's also an issue, you know, you mentioned her mental health of postpartum. Her and the actual officer that shot her showed up apparently for a horrific scene where a mom and a young child were, you know what happened. And I don't think they got offered really any counseling. Do you think that might come up in this too? Or is it just too far out of the weeds? What do you think?
I mean, look, it's the most stressful profession, bar none. I don't know the percentages, but the suicide rate of police officers is certainly pretty high. I mean, we read about this all the time in the NYPD. There was one last week. I mean, it just happens a lot. The trauma is real. It can be. You'd like to think that there would be services available. You know, the other thing is this, you know, policing is rightfully or wrongfully considered a male profession, and it's probably harder for a woman. And if you're a woman who's experiencing work-related trauma, especially in a town like this that you just said, there might be gender discrimination issues or unfair treatment. It may not be a great career move for a young female cop to say, I need help. I don't feel good because I saw something. It may lead to some out-of-date stereotypes about women, emotion, and handling things that if you're a young female officer, you'd say, I don't want to bring this up because I don't want them to treat me, you know, like I'm different. So, you know, these things are all issues. But I mean, at its core, to me, it comes down to whether why did this guy shoot her? There's reason to believe that the grand jury didn't necessarily believe what he said. So this case may already be in serious peril already. In other words, the officer's credibility
be shot.
I mean, God knows what that grand jury testimony is. I don't know, and whether it fits the evidence.
It's going to be interesting. That's going to be interesting to see when they're all on the stand. The boyfriend and that police officer. Going to be someone asked if I would be there at the upcoming hearing. I'm planning on going to every hearing I can. So if there's a hearing, I should be there, unless I have an emergency and I have to help a dog or something. But most likely, I'm planning to be there. So I want to play, like we had just mentioned, is play a little of this audio, because I think it is kind of revealing when you kind of hear her.
Sure, good afternoon. Calling come up first is Kelsey Fitz Simmons. This is docket number 2025-311 before the court in the defendant's motion. If the parties would please identify themselves for the record.
Good afternoon, James Gubachowski on behalf of the Commonwealth.
Good afternoon. Good afternoon, Attorney Moriarty for the Commonwealth. Good afternoon. Good afternoon, Your Honor. Martha Copley for the defendant, Kelsey Fitzsimmons. Good afternoon.
Hello, Your Honor. Timothy Bredel for Kelsey Fitz Simmons. She's present in the courtroom today for the record to my left.
Good afternoon, Mr. Good afternoon, everybody in the courtroom.
Thank you.
So I received a defendant's emergency motion for immediate release from the Graham order. So I'll hear from the moving party.
Thank you so much, Your Honor. Judge, this is an issue that causes Ms. Fitzsimmons a lot of pain. And I don't want to conflate her being able to pass the test because she's been passing them, but she has about 4 hours of pain and dizziness afterwards. And you know, I don't think anyone, and I know the court would share my thought that this shouldn't be a torture device for her. This shouldn't be something that causes her pain, impairs her rib healing, et cetera, et cetera. So, you know, we're not trying to get any sort of advantage over anything. We just want her to not be in pain for hours after these tests.
Shit about the dog. Does the dog look familiar? It almost looks like the same breed that you have, right?
No, I mean, I've got a pure lab, and the other one, Lola, I make a joke is, you know, 50% this, 50% that, and 50% 6 other breeds. No, that
Okay.
looks like a nice golden right there, right?
Yeah, a little bit.
Yeah,
Yeah.
but similar. I mean, look, I'm certainly biased towards retrievers and that sort of.
Me too. They're the best. Any type of lab, Goldie, I mean, they're all just the best dogs.
Yeah.
And B, you know, we just want her to not have the anxiety that if she has a difficulty doing it, that she's going to get a knock on the door and get locked up. We were told by the Elmo people that, you know, they may have to issue a warrant, and thankfully they didn't. And we appreciate, you have Mr. January's email regarding his own observations about what happened. And, you know, I think that says it all. That's someone that has no bias or interest, and, you know, probation enforces court orders, and that's that. And he is telling the court this is a problem. And, you know, this is something that should be addressed. And
Okay.
so I see this as a simple adjustment of terms.
I don't see it that way, just so you understand where I'm coming from. I don't see it that way.
Okay, can I?
Okay.
I don't understand what you're saying, Judge.
Okay, what I'm telling you, it's not a simple adjustment. One of the reasons she was released, and one of the reasons to ensure the safety of the community was for her to be alcohol-free. If she cannot do that or will not do that, that changes everything.
She's happy to be alcohol-free. She doesn't wish to be alcohol-free. It's just the means of determining that's the adjustment. That's what I mean when I say this is an
Okay.
adjustment that.
Well, a scram is what was ordered. Now, was she unable, when you said that there was a knock on the door, explain that to me. What
No,
happened?
Judge, that we don't want to have a knock on the door. She's living in fear of there being a knock on the door
Okay.
because of these tests. It's just not between the physical and then the mental anxiety. This is a very significant issue for her.
Okay,
And that, you know, we just want to adjust whatever means the court wishes to test her or figure this out is fine with us. But this is just a very difficult environment. And just, that's something that I just want to ask the court to adjust
Okay.
somehow.
okay, so you're asking the court to adjust the court's order that's been in effect for 3 days with no medical evidence to support your claim that she cannot do it.
Well, I think you have 2 affidavits and the email from probation. I think that's pretty persuasive evidence that this is extremely difficult.
The email
for her.
from probation is not evidence. If you have any evidence, now is your opportunity to submit it.
I don't understand the court's position. That's not evidence.
Okay, it's an email, it's hearsay. Commonwealth, do you have a position as to the submissions of an email as evidence in this hearing to relieve the defendant, Ms. Fitzsimmons, of a condition that's been in effect for 3 days?
I don't want to put anybody on the spot, but we have the person who sent that email here.
Okay,
What do you think about this so far?
Not much. The judge is combative, defensive, and wrong. The email, of course, it's evidence. It's being submitted in support of their position, and it's coming from essentially an arm of the court. I mean, probation is an arm of the court. So when the judge dismissively says it's not evidence, she's wrong. And then when a lawyer says, well, judge, it's evidence, she says, well, it's hearsay. So what? Now, hearsay is less reliable, but the guy's right there. He's available to be questioned. So this doesn't sound what I
Good
would call.
questions too.
I don't like this tone. I don't like the defensiveness. It feels not judicious. It feels like as soon as the application was made, the judge is wrenched up and ready to go. I mean, it hasn't gotten off the rails completely yet, like I'm told it may, but the tone and the defensiveness and frankly the wrong analysis about the evidence. I mean, hearsay is generally considered less reliable, but of course it's evidence. It you know, you can accept it for what it's worth, but I think an email from probation is a hell of a lot more persuasive than an email from Fitzsimmons's father who says she can't do this. I get it. You know, in that situation, you might roll your eyes and say, "Come on, I do better." But it's coming from an arm of the court, basically. So this is all troubling.
And she knows she got shot too. That's the other thing. Like, there has been some medical paperwork filed apparently in the past. So like the judge is aware. Like it's not like she's just making something up, you know? So
No, it's
do you
crazy.
think it's weird too that she immediately said that, like you said, that's not evidence, the email's not evidence, and then she goes, "What do you think, DA?" Like she's hoping that they don't want that as evidence. Like that's basically what she's trying to do, right? She's trying to put it on the DA's office.
Talked about earlier, you know, and the DA didn't really give her the lifeline, really, other than say, you know, you don't like the email, the guy's here, like whatever. So, you know, the DA is taking no position, which is better than taking an adverse position. You know, you can't say that in so far he's been the famous potted plant that we've seen elsewhere, but it's not exactly like they seem particularly that they care one way or the other. And it just seems to me that if, you know, they have over the course of the couple of appearances, they have the probation support. They clearly have proof that she's shot and it's difficult. They have proof that she hasn't failed any of the tests, right? We have proof now. There's a letter from her treating physician who says she has these problems. What are we doing here? I mean,
I know.
figure out a solution instead of fighting and arguing, looking for a way not to do it and say, you know, you're asking me for something and you have no evidence. And you're like, we have the probation people here and we have, you know, her condition. It's kind of obvious. Even if the judge had concerns about the reliability of the letter or email or wanted the medical evidence, the reality is she made it clear. You don't have what I want now. I don't want to hear this. And, you know, my understanding is in her mind, it was over. I mean, they had to file a motion for reconsideration. They were only relitigating this because the defense asked. So in other words, she had no interest in hearing what any future solution may be. You know, it's Miller time. It's time to go home. Forget it. I don't care. Send her to jail. What's for dinner? I mean, that's how it feels.
Yeah, the judge is abusing her power. It feels like that.
It doesn't sound like it's gone completely off the rails,
Not
but
yet. It gets worse.
The tone is not good. You can see
So
it.
you have,
Oh, sorry.
This isn't normal dialogue between, you know, a judge and a lawyer where there really is no reason to be arguing. You can disagree without being disagreeable. This feels for no reason.
Like it's personal.
Yep.
Bernie, it's your motion. What do you want to do?
Well, Judge, I don't think that I mean, is the court saying that papers and emails and affidavits are not sufficient?
This is an email from a probation officer. The court gives that 0 weight.
0 weight.
Well, then you have an affidavit from Ms. Fitzsimmons.
I want to ask you a quick question before I forget about it.
That is disgraceful. Sorry.
Yeah, that was just great. There was some pushback online, and I think it seemed like this person's a lawyer, honestly, and I think they have a beef with Tim Bradle more than anything. But they gave
Is this-
Bradle some shit that they said that Bradle should have had much more paperwork going in there. He should have had doctor's notes. He should have had all this stuff. I feel like Bradel didn't expect this judge to be like this. Like,
I don't know, but I
what
think
do you
I know
think?
and I think this is the lawyer who is basically an anonymous, miserable troll who
Yeah,
loves
I
to
think so.
tell every lawyer what they do wrong, but
Yeah.
doesn't even have a real name or identity. So I put no
Exactly.
weight in that as a legal expert. I mean, he's entitled to his opinion, whatever. But I mean, look, you submit an affidavit and you have probation documented on your side, and you have corroboration based on the fact that she's pumped full of lead. That's pretty
Should be enough.
strong evidence. And when you have the judge who said, and this is shocking to me, and I wonder how this makes the court staff in that building feel when the probation officer, again, who basically works for the court, okay, essentially, probably in that building all the time, in front of this judge, dealing with it all the time, who has no skin in the game. And usually if they do, it would be to make sure you better be complying, not on your side, writes a document to a judge saying, this is real. And the judge's flippant response is, I give that 0 weight.
Yeah.
That's disgraceful. I mean, you may say, look, this doesn't do enough for me, but to basically say that an email from one of these court staff means absolutely nothing to me, I could care less. That's not going to be good for the, court staff Christmas party.
Yeah, I wouldn't want to with her or for her or next to her.
That's pretty
I
shocking.
wouldn't want her as a friend, because she's not a good friend. You can tell. Sarah has a great point. She said they already have her medical records from September 8th, which they did. So they know her liver is lacerated. 2 ribs are broken. And she has collapsed lung, quoted, severe lung damage. They already knew that. She knew that already.
Yeah. I mean, again, there's plenty of evidence, to me, you can't even look at this, though, in isolation. You have to look at the whole mosaic. They did come back with the letter from a doctor, with additional evidence. And then she says, well, you didn't give that to me the first time. And, you have this purported letter, right? That word purported stuck out when I, glanced over what I read, the recent decision and order. That is a strange way to describe a letter from a treating physician at a hospital who's saying this is her condition. And the judge is saying, well, maybe, maybe not. So now the letter from the doctor means nothing. The email from the probation officer apparently carries 0 weight. This woman got shot. That the charges have been reduced by the grand jury. There's so many moving satellites with this thing. And it just seems that for whatever reason, she's finding ways to defend her position and not say, okay, fine. As opposed to just saying, look, I understand what you're raising. You probably should have done it this way if that's her view. But at the end of the day, if there is a way in which she can take the alcohol screening that accomplishes what the purpose of what the court wants, which is to make sure she's not drinking alcohol, then who freaking cares how it's done? That the answer is not my way or the highway. And if you don't do it my way, the highway means jail. Oh, you're silenced again.
I'm going to play it anyways.
And you have an affidavit from her mother of the physical observations of what happens. I think that's, the more persuasive evidence than a doctor saying something to the effect of, I think it's self-evident and it's common knowledge that if you have broken ribs, that it's hard to breathe.
What evidence do I have that she has current broken ribs and that she's suffering from broken ribs at this time?
Well, you have an affidavit from her mother. You have an affidavit from Ms. Fitzsimmons. And the other day we were here, I submitted I believe I submitted the instructions from Mass General about broken ribs.
Okay.
I mean, I would just argue that it's somewhat self-evident as well. Thank you. That it's somewhat self-evident as well. And that, she's having great difficulty here. It's been observed by probation. It's been attested to by her mother, and it's been attested to by Ms. Fitzsimmons. So it's just a very difficult scenario for her that luckily she has passed the test, but then she's got hours of pain afterwards. And the one that she had difficulty with, out of an abundance of caution, we were dealing with Elmo, and we were informed that they may issue a warrant. And
So I want to
then-
hear about the one she had difficulty with. When was that?
Except one on it. Well, so that's what I was saying. This. I don't want to conflate passing with not having difficulty. She has difficulty with every single test. And so she passes them in great pain. So she's had difficulty in every single one, equated, it's in the affidavit. So she has difficulty on every single one. So that's different issue than passing the test. So she's experiencing difficulty all the way through. But the one that she was unable to was 9/9/25 at 3:09 p.m., I guess.
And was that a required test that she was to do?
Yes,
And she was unable to perform it?
correct.
Okay, was she unable to perform it?
No.
What happened?
No. So this, since she's been.
Probation officer.
Yes, where in office?
Would
The
you raise your right hand,
probation
please?
officer.
Do you solemnly swear you will make true answers to such questions that may be put to you by the court or upon its direction, so help you
I
God?
do. Lauren, if I could just pass this up. This is
Sure.
information pertaining to all of our students.
And is that being submitted, Attorney Bradle, as an exhibit for the purposes of this hearing?
Judge, I'd be more than happy to do that.
It's not more than happy to. You're either doing it or not.
Yeah, sure. Go right ahead, Your Honor.
Okay,
It
so we'll-
just says that she passed the test, which is not an issue. The issue is that she's in extreme pain while doing it. Whether she passes. or not.
Okay, so there's one, Officer January that says incomplete at 9/10/25 at 3:09 PM. Is that right?
That's correct.
So what does that mean?
Yes. So what it means is there's a scheduled test that's programmed daily for her to be alerted and to initiate a test. And that happens. And so initially she answers the alert and attempts to take the test but is unable to complete the test. And based on my information, my conversations with Elmo is that is when she has difficulty either blowing as hard or as long, or a combination of both, into the machine to complete the test. So what happens after that is there are additional attempts to complete the test, which she tries, and then ultimately on that particular date, she successfully completes and passes the test on September 10th at 3:50 p.m.
Okay, what I have in front of me is an incomplete test at 9/10/25 at 3:09 PM.
That's correct. And then if you just look
And then
right
it
above
says
that,
passed at 9/10/25 at 9:30 AM.
okay, so you're looking, I'm referring to this the second document, it's multiple pages.
Mhm.
I think if you just go up instead of the one above it. the
Okay.
Incomplete is the.
So it's 3:09, it's incomplete, and then at 3:50 she passed.
That's correct.
So that's a period of 40 minutes?
That's correct. And you'll see the same thing.
So the other one, which is
September 9th, yes.
September 9th,
Again, at 3 o'clock.
but she
The test is initially incomplete.
at 3:09 and then it's complete at 4:21.
For, 4:20, 4:21.
So there were two times that she had an incomplete test. Is that
Yes,
correct?
Incomplete, and
And what's the procedure of the probation department when somebody who has a condition of release to have scram and to pass a scram test in a very serious case if they're incomplete? And I have 2 incomplete tests and I was not made aware of either one of them.
So my first job when we get an incomplete test is to gather more information. And so, which is what we do. And so in response to the incomplete test, we call Elmo, we gather the information, which is she answered the alert to take the test as scheduled. Unfortunately, she was unable to complete the test because she was unable to blow as long or as hard as needed to complete the test. So ultimately, at 4:20, she completes the scheduled test. There may be additional attempts in between, but ultimately she completes the test.
So that's for a period of
And so
an hour and 20 minutes.
that's correct. Now, in conjunction to the hour and 20 minutes, we also know that, and I observed it firsthand, that whatever the injuries are, which I don't know, actually doesn't really matter to me. But when I was doing the installation process and observed what was genuine pain, like genuine pain. So I know.
Any objection to any of the terms used by probation officer? Okay.
So
Are you kidding me?
we have all that information. We don't deem that non-compliant. She's attempting to take the test and she ultimately passes the test at 4:20. So with all of the information, that's not non-compliant. That's compliance. And with her obstacles.
I'm getting confused. What do you mean compliant? As far as when she was initially,
that's compliant with scram testing. She was ordered.
when she initially was, started to be monitored by scram and you went through the preparations. Is that
Yeah,
right?
that's correct.
Okay. So when something is incomplete, do you typically bring it to the attention of the
No.
court?
No, it's not.
This judge wants to get her, and it just she's looking for it.
She tells this guy, I put no weight on anything he writes, and here he is now under oath.
Right? I know.
And
What a
he's-
mixed message. That's such a good point, Mark.
He's explaining in his own opinion, which I understand there are evidentiary rules about opinions that people may have that are irrelevant, which you may read about in a few days and something else as well. But in this situation, he says, it's clear to me that, she was trying and was in pain. And for her to interrupt and look at the DA and say, are you going to object to this? Do you object to that terminology? As if like this guy, as a probation officer, can't just say, look, it seems to me that she was in sincere pain. It feels biased. It feels like she doesn't want to hear this and that there's a bone to pick for some reason. Like it's just, this is very hyper aggressive over nothing. I mean, I don't know any judge who in hearing something like this in a bail argument, essentially, let's call it what it is. This is a freaking bail argument. Okay. Forget all the other words for it. Who would interrupt the testimony of a probation officer who is saying she's trying, she did eventually complete it, she did eventually pass it, but when she couldn't complete it, she was in real pain, where the judge, sua sponte, on her own, like literally interrupts without an objection to, I mean, this feels like Canoni and Lally, right? Is there an objection? Is there an objection? It just feels biased, and there's a hostility in tone here, even to this probation officer. What do you want from this guy? He seems pretty competent. He seems pretty unbiased. It just turns out that he has an opinion that the judge clearly doesn't want to hear.
It sounded like she wanted to hear something else, didn't it?
She wanted to exclude his email. It's not evidence to me. It's hearsay. It's meaningless. And now when he's under oath, I don't want you saying she was in pain. How do you know? How do you know?
Yeah. How do you know?
Well, I don't know. I mean, it could be the bullet in her chest. That might tend to do it.
You would think that might, but not for this judge.
Oh,
Yeah, I don't know what.
So if something is incomplete, as in this case.
I'm sorry, Mark. What was that?
Going to say, I don't know what the origin of this hostility is, but this is really bizarre tone for what this is. This is a real reasonable modification being sought over a real ticky-tack thing. Again, just find a way to have her tested. You don't have to give this probation officer the Inquisition. Just find another way. I mean, it's as if her view is, I don't believe you guys. I think you're all lying and trying to pull one on me. And there feels, a little bias, a little hostility. And, that we'll see. Maybe that's worth probing. I mean, because this seems like an irrational reaction to what's happening.
It really does. That's why I was like, wondering about where she lives and who she might be related to or connected to. Something doesn't seem right with this.
At 3, on September 9th, at 3:09, we have an incomplete test, which is a scheduled test.
Mhm.
And then we have, that's simply not the non-compliance. If she had missed the test, that would generate additional responses from Elmo, and then that would determine whether or not there's actual non-compliance. If someone missed a test because they were down in the basement doing laundry, and then came up and realized that they had a test, took an on-demand test 20 minutes later, and passed the test, which means there's no alcohol in the system, we don't deem that as non-compliant. That's compliance. If they missed the test and additional notifications were made by the electronic monitoring office regarding the missed test, and she failed to respond, or she failed to take an alert for another on-demand test, now that's non-compliance, and we would initiate a pretrial violation notice and notify the district attorney's office. This particular case, I don't deem non-compliance because she's complying with the scheduled program. I'm aware of pain based on my observations from the installation process. So as long as she's attempting to take the test, continues to attempt to take the test, and then ultimately takes the test, that's not non-compliance. That's someone that's,
Well, that's your
for me.
position. That's non-compliant.
Well-
It's really up to the court to decide whether somebody's compliant or not with conditions of release. What you're saying is those situations you described is what you deem as appropriate to bring before the court.
It would, so I guess it would never be brought to court by way of a pretrial violation for an incomplete test with the information that I've talked about. So no, an incomplete test does not initiate a pretrial violation order from our end, because there are many reasons for a test to be incomplete. And there are circumstances where someone misses a test and then takes an on-demand test. That's not intentional non-compliance. And the goal is to test to ensure that the person's sober, and we don't deem that non-compliance. We never have, and we never would in this case, initiate a pretrial violation proceeding based on an incomplete test that was subsequently passed. And so the schedule for her to be tested is something that we discussed. It wasn't ordered by the court. The court ordered someone to be out.
What do you mean we discussed? So she knows what she's going to be tested?
With Ms. Fitzsimmons, I discussed with the defense counsel about creating a testing schedule, because it's more practical to have a schedule in place. There was no schedule that was ordered by the court. There's no frequency of testing that was ordered by the court.
It was
4 times a day, 3 times a day. None of that was ordered. She was ordered.
It was random screens. Excuse me, Officer January. It was random screens. Now you're telling me she's on a schedule to get tested? Is that what you're telling me?
We created a schedule.
With
as we always do.
Okay.
As we always do. Not in this particular case. We always do.
It was random screens that were ordered.
Judge, I don't have that. I don't have random screens anywhere in my materials, for the record.
Okay.
I don't know nothing about random screens.
Okay.
Judge, just so I can clarify that.
Yelling at him, saying, I called it to be random. And they did it like 3 or 4 times a day. It's like, what is the issue?
This is disgraceful. This is an inquisition. And the irony is, this guy is a credit to the probation department. He is
really
as reasonable as a reasonable man or person can be.
Exactly.
He seems quintessentially fair, logical, well-mannered. He's not looking to violate people. He's not looking to help them violate either. And he's simply saying what she did isn't wrong. We would never move to violate her for this. So like she's in full compliance. And the tone of the judge again, you know, I decide, you don't. And wait a minute. Now you're telling me I ordered this, you're doing, I mean, cross-examining a probation officer is simply saying, look, she took a test, she tried to take it, she couldn't do it a couple times, she took it later, she did do it, she passed. That's compliance. In our definition, we do violate people, but we would never violate her. And everybody's all bent out of shape over this. This is crazy.
The best part's coming up. We got like 10 minutes left. We may speed up this a little bit, skip a part, but I don't want to miss anything.
When we get an order, someone's placed on pretrial conditions that
I'm
include
going to move up a couple
for
seconds.
mid-afternoon, we'll schedule one. Enter a schedule is if the court specifically said, I want the test to be done randomly. I don't want her to know when the test is coming. And the test to be done randomly. And at that point in time, we would take her off a schedule. And then we would notify Elmo to be tested 4 times a day at random.
Okay.
So that's done on this case and it's done on every case.
Okay. Attorney Bredel, do you have anything else to submit?
But I would just offer, I respect and I heard your Honor's take on the probation email, but for the record, I would move that into evidence as well. And I just want to also.
Commonwealth, do you have a position as to the admission of the email?
Well, I think we just heard with the email.
All right, so the email is excluded. Anything else, Attorney
No, my
Bredel?
objection, Your Honor.
Sure.
And Judge, I just want to state that on the pretrial conditions of release, that says,
No, she just excluded the email, but she,
I mean,
what is up with, from the probation officer after she talked to him. I had him on the stand. I mean, it just,
saying I have his testimony, so who cares? But the fact that she's objecting or asking the DA to object, the fact that the DA kind of gives a half-hearted, well, yeah. I mean,
guess.
honestly, when you're a prosecutor, read the room, man. Just say,
Yeah.
we have no position on it and let the judge do it. Yeah, you can see this is going sideways. You can just tell she's getting ready to deny this.
yeah, you're going to get,
comply with remote alcohol breath testing.
Okay. I don't know if that's what was ordered. I'm going to go back and listen to FTR.
I can tell the
No,
court from what I
now
said,
she's going
I
back.
didn't,
She's taking a
remember
break.
any use
I mean,
of
you may very well be right, but I'm going to go listen.
Judge, I just want to clarify something.
So basically, there is a gap here, but you don't get the gap. But she basically goes back to check the tape from the previous hearing to see if she did the random. I mean, that is, who cares? Like, I don't, especially if they're testing her that many times a day. It doesn't, random would be easier to pass.
My email, and I know but it's important that the court knows, I didn't make a recommendation that the scram condition be vacated. I never did that. I never suggested, it's all that email was.
Attorney, Officer January, nobody's asking you questions. Your testimony is complete. Are you asking to make a statement to the court?
Well,
Sponte?
if the court's under the belief that I recommended that condition be vacated or removed, then yeah.
I haven't said anything one way or the other, sir. We're here for one purpose and one purpose
Okay.
only, and that's for the motion to vacate the scram device. So do you have anything else to submit, Attorney Bredel?
No, no.
Okay, Commonwealth, do you have anything?
No, I have no evidence to submit other than the arguments that I talked about, how important that the Commonwealth's belief is. In light of the court releasing the defendant, that testing be done.
Okay. Attorney Bredel, I'll hear, first of all, I do have a question. So Ms. Fitzsimmons is able to do the scram, is that correct? Or is she not able to do it? I don't know. Is she not able to do it?
I think, that depends on whether the court is willing to tolerate that the material represented in the
The court
affidavit.
is not tolerating anything. Okay, let's be clear. I'm not tolerating anything. The court is not tolerating anything. Ms. Fitzsimmons is a defendant. In lieu of incarceration, my order was that she submit to scram. If she cannot do that, I need to know that. Can she do that or not?
She can do it
Okay,
under the terms that are
So-
laid out in the
so
affidavit
you're saying she can do it on her own terms?
with significant pain and dizziness.
He didn't say on her own terms. She just coming up with things he didn't even say.
And having to recover for several hours.
I understand what you're saying. It is certainly not the court's intention It's not the court's position to have Ms. Fitzsimmons in any pain at all, so I appreciate your argument. Do you have anything else to add?
I would suggest, Judge, that I think there's other ways to do this. If the court wishes to have her tested for alcohol compliance, lack of alcohol, that's completely fine with the defense, but just the means that's being employed is kind of a torture device for her.
Okay.
And so we object on due process grounds to that,
Oh, okay.
but
It is not this court's intention
I
to
understand.
torture Ms. Fitzsimmons at all. The court's goal is to make sure the community is safe and Officer Noonan is safe. So I hear you loud and clear that the defense views Ms. Fitzsimmons having to do the scram as cruel and unusual and torture. Is that your position?
Well, that's an Eighth Amendment position. I suppose that
Okay.
can be put in there as well. But Judge, I think that, that there's probably other alternatives that she could do that I believe are out there but I know that might step on the court's other order for house arrest, that she would have to go to a facility. I know there's like urine tests and other things like that. So I know there's other possibilities out there that, again, she's not trying to use this to create a situation where she can go drink alcohol.
Okay.
It's not at all what this is about. So I just want to ask the court to consider any other alternatives that might not pose this type of an issue.
Okay.
Thank you.
Attorney Gubitosi or Attorney Moriarty, do you have anything to add?
No.
Okay, I'm going to leave the bench for a few minutes and I'll be right back.
Court, all right.
Your Honor, we're back on the record with the Fitzsimmons matter.
Okay, good afternoon, everybody. So I have reviewed everything again that's been submitted to me. And I will state for the record that Fitzsimmons has moved twice in a 3-day period to amend her conditions of release. On neither occasion has she submitted any medical evidence to support her claims. The imposition of conditions is the court's order after careful consideration of the evidence to fashion the least restrictive conditions that will reasonably assure the appearance of the defendant and the safety of all other persons in the community pursuant to General Laws Chapter 276, Section 58A2B. Just days ago, the court concluded that the condition of remaining alcohol-free and submitting to scrim monitoring was necessary to ensure the safety of the community. After a thorough review of all of the arguments and submissions by the Commonwealth and Fitzsimmons, that conclusion remains unchanged, regardless of Fitzsimmons' claimed physical limitations. Based on an affidavit submitted by Fitzsimmons' mother, the testimony of Assistant Chief Probation Officer Jeff January about his observations of Fitzsimmons' apparent pain during the scrim installation, and the representations of Fitzsimmons' counsel that it would be cruel and unusual punishment and torture to continue to require Fitzsimmons to comply with the condition of being monitored by scrim, the court concludes that Fitzsimmons cannot abide by the condition of being monitored by scrim. Without this condition, which ensures that she does not consume any alcohol, the court cannot assure the safety of Officer Noonan and all other persons in the community. Accordingly, the court's prior order of release is vacated, and Fitzsimmons is ordered to be held without bail pursuant to Mass General Laws, Chapter 276, Section 58A. And a written order will
May I
follow.
address the court?
That's the court's order. Thank you.
All right.
All right, Jack, I ask you to stay your order pending the SJC. And there are other alternatives Your Honor can accomplish.
Was there
What is she so angry about? Her voice is cracking. She sounds nervous. She sounds so angry that it's almost like her voice is cracking and there's so much anger and hostility in there. That's just embarrassing. And I mean, there are times where judges rule against you. That's not even when they're wrong and you think they're crazy, but you don't hear the invective and tone. I mean, you can feel her
like a
shaking.
spurned lover or something?
You can
Yeah, it's
feel
something.
her. What are you so angry about? Why are
I
you so
know.
pissed off? You ruled against them. They were very polite in their argument. You rejected it improperly, in my view, but nevertheless, why are you so jacked up in doing this? And there's an affidavit from her mother. I mean, just the tones and the dismissing, the useless probation officer. You don't have this, the purported letter from the doctor. This is just another example of why everyone looks at Massachusetts and their criminal justice systems as just a complete joke.
Yeah, seriously.
Bad
There was a
meaner is worse. It's just judges make bad rulings all the time. It happens. I mean, somebody wins and somebody loses every day in every argument. But what you don't usually see is a judge with just such hostility, not only in the hearing itself, but in the ruling. I mean, you can just really feel the shaking and anger and venal, everyone get out of here.
To when I was there the first day when Kelsey got released, because there was a conversation about the surgery and the ankle bracelet and that it might have to be removed, and the judge made a big deal about it. And it was the same scenario. The probation officer was cool with it. And I talked to Kelsey after, and she was like, "I'm gonna just cancel the surgery tomorrow. Yeah, I'm just gonna cancel my surgery for my liver." And apparently, from what Denise is saying, she had to postpone her surgery because of the bracelet. I mean,
you have to feel concerned about, the appearance of bias, minimizing affidavits because they come from you and your parents, minimizing the probation officer as useless because he's supporting your side, minimizing the doctor because it's supportive as, maybe that's what he said. The tone to the lawyers, the emphasis on, mother and defendant and things like that. It just sounds, making sua sponte court objections over things that the DA is obviously not complaining about and doesn't care about. It feels like the finger, or at least there could be an appearance that the finger was on the scale, and that, whether that's true or not, an appearance of a conflict can be just as bad as an actual conflict if that's what people think. And the problem for the system is you watch this video and most sane people are going to say there is at least an appearance of hostility and just, maybe hatred is too strong, but displeasure and just a lack of patience with the defense, as if there's some belief that they're trying to game the system. This is the third time you've been in front of me trying to modify something and you didn't do this. And you can't be that biased against someone in court just because they happen to be the defendant. Doesn't mean you have to believe everything they say, but that was an atrocious proceeding.
Sarah Stiles is a question that I want to bring up, and I want to know what you think about it, because in the past I would have said no way to her, but now I'm kind of sympathetic to it. Sarah Stiles says the biggest issue I see is the judges in Massachusetts are appointed, not elected. The people have no say. Do you think it's better appointed or elected, or does it even make a difference? Is there good and bad things about each way? Is that even a thing that we should even consider changing?
You're damned if you do and you're damned if you don't. Okay. If the judges are appointed, then you're in the hackorama, the party bosses and all of that. Right. And then you're going to get, no question, unqualified people who become judges because they suck at the public trough. They go to the party functions and that kind of thing.
Sounds like Massachusetts.
Right. Now, the problem with elected is, it's more, more like a republic form of government. I get it. You vote and whatever, but then you run the risk of judges who may, and be more public pressure and veering too harsh or too lenient, depending on the climate. So I think you're going to have a problem either way. And then, in some states, it really doesn't matter. So like, for example, I just have New York's the only example I can give because it's the one I know. Lower court judges, which are called civil or criminal court judges, they basically get elected and they're lower court judges. Okay. And the higher court judges, which are Supreme Court judges, are supposed to be elected. But then what happens is 90% of the Supreme Court judges are what they call acting Supreme Court judges, and they just get picked by, the court administration people and bumped up, and they're not elected. So they're originally might be elected in a different county in a low court race, where even in New York City, they win an election by like 27-14 because, the party bosses back them. And it's just, I think you're gonna, there's no perfect system to this. I don't know anything about this judge or how she, what her credentials are, other than she was a prosecutor.
She was a prosecutor and she was a defense attorney. So I don't know.
She's got something for, the lawyers and client in this case. And whether that's more out of bias in favor of the police officer, alleged victim, or more against these people, it's not often that you will see a judge in these kinds of rulings lump the probation officer as one of the not credible defense guys. That I've never seen.
I know that is when she went after the probation officer. It's like, and you're working with him every day. Usually they're all chummy. And everyone, usually the court officers, they're all buddy buddy. And it's like to see that, I was just like, I've never seen this before.
They normally have a ton of weight. Okay.
Yeah.
Not just for the reason you just mentioned, which is we all have to go along to get along. We all work together.
Yeah, we're together every day.
But most judges also know the limits of their expertise, right? They rule on legal issues. But the question that is before the court, it's more of a factual question about what's going on with the Scram test and why isn't she taking it? And 99.99% of the time, any judge is going to defer to the expert of that, which in this case would be the probation officer, who says, look, she's not in violation. I saw her try. We're okay with this. This is going on. It's no issue here. And she's just looking to not accept that.
I kept saying when I heard it the first time, it's almost like she wants to be the probation officer and the judge. She wants to run their department too. It's just, it felt like micromanaging.
It's not common that you'll hear a judge basically say, well, that's great. That's what you say, but I'm the judge and I decide. Not usually with a probation officer who's just offering, their input on what's happening and why they don't believe there's anything to it.
Now, I know some of the family members are probably watching tonight. I've heard they've sent a few texts over during the show. How likely do you think that she might get released now? Is she stuck there, or is there a good chance that Tim Bradle can get her out?
Well, you have to go through the process. So hopefully, they'll get her out. I mean, what's frustrating about this is all hyper-technical. This is all legal mumbo jumbo. And yeah, I'm a lawyer and I'm saying, well, the law can be crazy. This is basic, rudimentary common sense. Okay. There is justice and injustice. This is profoundly stupid that she's rotting in jail over this. This is just, you'd laugh and say this was a joke if it wasn't so serious. And, she wasn't being held, obviously against her will, away from her, kid. I don't know what kind of treatment she's getting on whatever other issues. This can't help. That's for sure.
That's a good point. Because she has two doctors that she was scheduled to see multiple times a week. And I've heard from the parents. The parents said she doesn't get to see her doctors when she's in jail.
I mean, look, I don't think this is going to be the end of the world or anything like that, but there's no reason for her to be there over this. There's no violation here. It's really important. There's no violation. All right. The judge wanted the Scram ostensibly to satisfy that she won't drink. There's a problem taking the Scram, and all the defense is saying, can we just find another way to prove to you that she's not drinking? And we're happy to do it. And apparently the way that the judge has thought this through is, well, if she can't take the test that I ordered and you don't have literally something convincing me right now, then I believe, I'm going back and I find her a danger because I don't know that she's not drinking and you haven't satisfied me with any condition that will satisfy that condition. So what we'll do is, why don't we just put her back in jail and, goodbye, have a nice day. And I'm going to go out to dinner. That's very unfortunate. And that's, again, why people get fired up. And that's why whatever support that she had already is growing exponentially, apparently. People are watching this tonight. Other people will watch. I know other reporters, have been talking about it. It's only going to grow and grow. And this probably, in hindsight, will be a decision that the judge perhaps will regret, because what the judge is doing is building an army.
Exactly. I got to say, too, we have pinned in the chat tonight, all night in the chat, her fundraiser, Help Kelsey Heal, Give, Send, Go. When we started promoting this, like about a week ago, It was in the. We weren't over 10 grand. It went over 10 grand today. It's over 12 grand right now. It just keeps going up. So I'm that's big. I'm glad people are donating and supporting her. I know people are going to show up the next hearings. We got some hearings coming up. The big one is the criminal one, October 7th. So I hope people can come to Salem Superior Court. Mark, last question about Kelsey tonight, and then I got one question about Diva, and I'll let you go. The family is listening, I'm sure. Any advice that you have for this family right now? Because I know that they really do care about their daughter, the mom, the dad, the stepdad. Anything you can give them right now, just because they are really upset. And like I've heard from the dad quite a bit. This is a girl that did everything right in her life. She's never gotten in trouble. She's done everything on her own. She was a correction officer. I guess she's done really well. She's actually in law school as well. She got good grades, and they're really concerned. What would you say to those parents tonight if they're watching?
This is war, and you have to treat it like that. And in war, you can lose skirmishes and battles, but you have to keep going. And clearly, you need her out for a lot of reasons. For everyone just to feel better, but also to prepare her own defense. Don't underestimate the burden this does. I mean, she's in Chicopee, if I understand this correctly.
Yes. Yep.
Like way the hell out, like way out that way. I mean, when I grew up,
for the family. Yep.
Past 495, you lived in the middle of Kansas.
Exactly.
So it's far away. It that hampers lawyers' ability to prepare a defense. But they have excellent counsel. They know what they're doing. At some point, she's going to get out, and you need to just hunker down and prepare for battle and win the war. And, what I often tell people is it's going to be a bumpy ride, right? There's going to be a lot of turbulence, and you're going to have to buckle your seatbelt. And right now, the turbulence is pretty heavy. But, if the facts are on your side and the law are eventually on your side, put on your seatbelt, take the turbulence, but the plane's eventually going to land. And, they have to look forward and just hopefully get her out as soon as possible. But there's a larger battle too, right? They're trying to convict her. It's going to cost her job. It's going to cost her liberty. Just, you have to trust the counsel that you have, good counsel, and just keep fighting and lean on the support. I mean, clearly the support is growing and growing. It sounds like they're getting financial assistance or will be. And I'm sure they're familiar with all this, free Karen Reed and all the, Aiden stuff and all the other stuff, the Sandra Birchmore stuff. It's the internet, but, it's pretty powerful, both financially and emotionally, the type of support. So for all they're going to start doing standouts and all that stuff.
I would not doubt it.
Maybe, they, I don't want to make light of anything, but, you could draw more people because it's, up north. It's getting towards, what's up there where, the good eats are.
Well, Halloween you're talking about?
I'm talking about like, once you go to the North Shore, you're not far from Kowloon. That's a nice.
Kowloon. That's right.
Not to make light of it. The point is though, I'm sure they're going to like start rallying. And the more attention that gets drawn on this, the more people that get into this, you also get your Twitter legal army. People they start looking at documents.
Olivia Lambeau's on it. She's on it. Oh yeah.
Yeah, no, she's pretty. Actually, I know this from.
And Melanie, Melanie's going through every document, every single. I got to say, having Melanie just having Melanie, it's been, I think, amazing for the family. So.
Yeah. So.
And they're all coming out. I saw Brother Counsel's been covering it now, and yeah.
Yeah, I mean it's a mess, and again, the facts of the actual case will have to come to bear at a future date. But at least what you've seen so far, this feels just not like a good test case for having confidence and credibility in how the court system is supposed to work.
Not at all. The last question I want, someone I was asking about, Dever, whatever we call her. What did you think about that? I'm surprised she voluntarily resigned. I figured she would be let go or fired or something, but she resigned, which I was shocked about because, I mean, where's she going to go next? What did you think about that?
Um, I mean, I feel bad for her in the sense that, she's young. At least initially, in Karen's case, it appears she was doing the right thing. I mean, in terms of what she said, almost certainly felt the pressure, the blue wall, got leaned on, left, right? Let's not forget that. She went to another department, got called into the corner office by the commissioner, which is bizarre. Story changed. Story was absurd on its face. I mean, absurd on its face. Her demeanor was atrocious. Her behavior was childlike. It was inappropriate. It was unnecessary. It wasn't helpful either to the prosecution. And so I want to feel sorry for her, but the more I think about everything that happened, I come back to the same place, which is she made her own bed. She made a choice. She had, multiple chances, and, she took, bad choice road, as they say, right? I'm going to get all like, Breaking Bad again on people, but, don't want to start giving the Mike speech about, when you come to that bad choice road. And she took that road multiple times. And I just, the one thing I feel bad for her is on the witness stand, she was just a complete clown. I mean, she was like a 10-year-old child, and it was sad to watch. I mean, it really was, but she's not fit to be police. She's not emotionally mature. She's not credible. So for whatever reasons, she made her choices. I don't know what she's going to do with her life. I mean, she's a young woman. I feel bad in that way.
I feel bad too, because like you said, I feel originally she did make the right choice, and then the pressure came down, and I do feel bad for her, even though, like you said, she deserved it. She made the wrong choice, especially affecting someone's life like that.
She had so many chances to take the off ramp from this, and she just went the wrong way. And, maybe someday people will find out about that. But the reality is no way she should have a gun and badge. No way she should have arrest power. No way cases should rise or fall based upon her credibility. So beyond that, I don't know what she's going to do. I mean, I don't really care either. It's not my concern, but so I applaud her for resigning, because she's not fit to be a police officer.
You know what kind of bothers me in this? It's like when I mentioned Hillary earlier, her underlings went to. It's like Cox, the guy who had the meeting with her, the commissioner. He's still working. He hasn't resigned. I just feel like he should be held to a higher account than her, and he's still working there and she isn't. So I don't think that's fair. I think that he should actually have much more scrutiny on him as the police commissioner.
Of course. I mean, but we all know how it works too. She's expendable. She's probably a probationary officer anyway, or, depending on how long she was there. But, the other thing that's unfortunate for her, the internet's forever, right? And I mean, that video of her performance, even if she kind of fixes herself and reflects, and, it could be unfortunate if in 10 years, there's this footage of her disgraceful performance getting not even cross-examined. I mean, kind of, sort of, obviously she was a hostile witness at that point, but to see a police officer testify in that manner was just an absolute disgrace.
Said I was done with the Fitzsimmons questions, but I got one more. Bay State said, talk to the press, Mr. Fitzsimmons. Give them your side of the story. Don't let them control the narrative. I think they're talking about the dad. I think the dad would love to talk to us on the record, but I think he's just listening to the attorneys, and he's going to do whatever they tell him to do. What do you think? Do you think it's a good strategy to have? Because the father is very well spoken. Is it risky to have the father speaking? What do you think, or the mom? And what do you think,
It would
Mr.
be,
Bederow?
it would be unfair for me to even comment because I don't know factually.
Details.
I don't know what they would say. I'm not privy to those conversations. The one thing they should do is listen to the lawyers, but they would be in a better position to know whether in any given case it makes sense to speak out or not. I mean, I think as a general matter, shining a light on this is a good thing, but whether that should be from any one individual talking or not talking, I mean, it would be unfair. It would be unfair to Tim, frankly, for me to even offer an opinion. I don't know, what their analysis is, what they talk about, and tactically what they want to do or not do. So I wouldn't even venture to guess other than listen to the lawyers.
Fine. Well, I appreciate you being here and spending a couple hours with us, attorney. 2.5 hours, actually.
Well, time
Time
freed
goes
up.
by quick.
I've been working like a dog for weeks and weeks and weeks since I got back from Florida, and I'm kind of,
You
I'm
needed
kind of
it.
done with this project. So it's fine.
Well, we're looking forward to reading all about it. Aiden's got a show right now, and apparently it's called The Mega Motion. He must be talking about it tonight. So,
I don't think I'll watch.
well, thank you so much again for being here, and it was great. I gotta say, I didn't get to go. I was bummed that I didn't go to Aiden's thing. But what I did enjoy was watching you having the time of your life. I was like, Bederow's having fun. That makes me feel good. Just watching you there, just looking around, and it just looked like you were having a good time.
Just go where they send me.
Yeah. And then you could tell the crowd loves you. I saw women were reaching over and they're all trying to hug you. They're all trying to get to you.
Smart crowd, you just go with the flow.
Oh, I want to thank you so much for being here. Oh, I guess Turtle Boy's on at 9 tonight. So perfect. We're not cutting into him tonight. Sometimes he goes 8. Tonight he's going at 9. Thank you so much, Attorney Bederow, because I definitely want to watch Aiden tonight. Thank you for being here. We'll catch up with you real soon. I also want to get an update on in the future when you're ready to talk about that other client, because we had a conversation about some things that are going on with a client you really can't talk about. It kind of went viral. We put that little clip up.
I would never talk about the client. If you're talking about that stuff with, the famous dead guy. I mean, that conversation will never involve anything about a client, but in terms of, what's available to be discussed, what's public and whatnot, we're not naming names or anything like that. That just time's not right for that.
When you're ready to discuss that any further, I'd always love to talk about that because I know how much it means to you.
It's very important and it means a lot. It does. It's most important thing I've ever been involved in.
Wow, that's saying a lot because you've been involved in some big ass cases like the FBI agent and just Aiden's case too is a big one. So I mean, and I know there's other ones that we could go on and on. I mean, so for you to say that, it must be something.
Yeah.
All right. Well, keep us updated and thank you so much for spending time with us. And we'll see you soon, Mark.
Take care. All right. Bye-bye.
Bye now. And like I said, we're raising funds tonight for Kelsey. If you want to make a donation tonight, much appreciated. I love watching that go up. Last time I checked, we're at 12,120. It just went up again. 12,226. I'm also going to throw in my Give, Send, Go too now, since it's we've had Kelsey's pinned all night. I'm going to throw mine in there if anyone wants to donate as well, especially since we have the ticker going on the bottom. If you want to make a donation, you can definitely do so. I very much appreciate it. We've had some good support coming in for both of these. I really appreciate everyone who's been supporting and donating. As people know, I am being sued in a defamation lawsuit. Appreciate everyone's support on it. I'm going to go through a couple of the super chats. Thank you so much. OnlyFans says Monster Mega Mark Motion OnlyFan is looking forward to that. We all are. I can't wait to see that. I want to thank B Crumbs, gifted 10 Young Jurks memberships tonight. Thank you so much, B Crumbs. Congrats to all the people who got memberships tonight. You can post some special gifts now in the chat. Sui Generous sent $5, said she didn't violate order. Bradel only asked for a different test. Judge knows of different tests. And mass hearsay can be considered in this type of hearing. What the heck? I know, right? I know. The whole thing was just makes no sense. Jen O, one of our moderators, says zooming in on Bederow face for the next part. I bet we all were, Jen. Not that Dina. Oh, a different Dina sent $20 and said, let's go. See you October 7th. I'll be there. It's going to be at 9 a.m. October 7th, Salem Superior Court. Like I said before, parking. There's a big parking garage, T station, train station, bus station. It's all the same complex. There's a big parking garage there. It's pretty cheap. So if you're driving out of town, you can park in the parking garage. Shouldn't be a problem. I know some people are worried about Halloween, but the Halloween crowds don't get there until later in the afternoon. You'll be fine at 9 a.m., especially with that parking garage. You can also take the train there. It's very easy to get to. It's 1 block from the train station. So I hope to see people there October 7th. Thank you so much for that, Dina. I'm going to read the message again. She said, let's go. Let's see you October 7th. Be there early. I will be. Parking behind the district court is plentiful, but it's October in Salem. Train is an option if it drops you right across the street. Free Kelsey Fitz Simmons. FKF. That's the new movement, I guess. Thank you so much, Not That Dina. I'll see you there. Not That Dina. I will be there. Amnot 23 Cheryl Lynn sent $1.99 and said, how is this not a violation of the ADA? I know, I don't get it. I don't get that. You'd think it would be. I'm sure that's probably going to be part of the SAC, the SJC appeal. Kat Randall, member for 6 months, it says trust. We got to trust the system, unfortunately, but it's not that trustworthy. But we trust us. We're going to show up. People are going to show up. And like JD said, Halloween is the end of October. It's true, but the tourists start coming in. First day in October, they're already here in September. I live around here, so I know. But the tourists aren't coming out at 9 a.m. They don't show up until afternoon. In general, it's the evening crowds that get big. We'll be fine. There's going to be plenty of parking. That garage is big. It's not going to be filled up at 9 a.m. Trust me. Yeah, it is right on the water. And Salem's beautiful. If you haven't come up here, it's right on the water. A lot of restaurants, downtown Salem. It's nice. Come check it out. You'll have fun. A lot of tourist spots, too. A lot of shopping, a lot of restaurants. Salem's fun. If you haven't been to Salem, it's a good opportunity to come up here. I'll be there. I definitely will be there. And there's also a family court probate hearing. That's the last Tuesday of the month of September. That's also at 9 a.m. That's also in the same area. It's just a different building. It's one building over. So all the same directions. That could get rescheduled. So definitely check our Twitter or our show and make sure, or whoever you're getting your information from, because you don't want to show up to that one and have it be canceled. It may actually be canceled. But October 7th is on no matter what. October 7th is happening. Trust me on that one. Yeah, Salem is great. Salem is a lot of fun. You'll have fun up here. The judge did have bully vibes, no doubt about it. $9.23. Sorry, Glamasus. I may have said that wrong, huh? It's not the last Tuesday. Is that what you're telling me? I've been saying it wrong. It is 9/23. That's the family probate date. 9/23. Thank you for clarifying. You saved me. Thank you. 9/23. September 23. Uh-oh. Do I need the Allegra D? You're right. It's probably allergy season again, right? Mark saved me last year. That was, I think, springtime, actually. Yeah, the Allegra D. That was Mark's suggestion for my. I all of a sudden get this wicked allergies this spring, and it really did help. I'm a big Allegra D fan now. And Salem is gorgeous. There's a lot of great places to eat too. So I hope to see some of you at some of these hearings up here. Yeah, there's a lot of awesome coffee shops too, right? There's a lot of witches up here. It's ragweed, huh? See, I think I'm good in the fall. I think it's the spring that I get the allergies. We'll see. If I start getting allergies again, I'm going back on the Allegra D. You know what I want to do? Let's just do a couple things before I leave here. All right, this is my give, send, go. I like to just, every time I do a show, I make sure I thank all the people who've been giving donations recently. 17,150. It's amazing. Thank you so much. Run the World gave $50 yesterday. Said thank you for being one of the very good ones in this world. Thank you so much, Run the World. Anonymous Giver gave 5. Jackie gave 5. Lisa Taylor gave 30. Those are the most recent ones. Casey, Groovy Cheryl. A lot of those came from Lady Zelda, who did the show the other day. Thank you so much, Muzzy Beer, Lisa Taylor. Thank you, everyone who's been given the Give, Send, Go for my fundraiser. I'm going to pin that right now in the chat since we've had Kelsey's pinned all night. If anyone wants to donate, you can donate to my defense fund as well. We got 2 defense funds we're promoting tonight. And I know some people can't donate. If you can't afford it, please don't. If you're struggling, if you're not able to, if you're worried about your food bills, your electricity, your rent, whatever, don't donate to us. Only donate if you can afford. And I appreciate everyone who's watching, even just watching and sharing. It makes a big difference. You guys don't even know. Just watching alone is a big contribution. I want to thank everyone who watches and shares and supports. All right. Almost caught up. All right. So I just put up my Give, Send, Go up in the chat too. At the top of the chat now. Can I tell you who's suing you? I've gone over it so many times. I've gotten sick of talking about it. It's a guy who runs a nonprofit. And we have done some shows on it. So if you want to find out more information, just look on the Young Jurks YouTube and look back a couple lives. You'll see them. I'm just reading the chat. I love reading the chat. His name is Harry Gene Jakes. That's the guy who's suing me. That's his name. Harry Gene Jakes is one of the names he goes by. I think he has a few different names, actually. But Harry Gene Jakes is the guy who's suing me. And his nonprofit's called the Big Hope Project. And we've done quite a few shows on it. So just if you want to hear more about it, go look at those shows. I'm going to close the show off. What I want to do is I'm just going to continue to play this press conference. This is a different press conference. This is the one that the Essex County DA, the former police chief of Salem, and the former state rep Paul Tucker, he's now the DA of Essex County. Here he is with the police chief of North Andover. This is the first press conference, the first we heard about this shooting. And I want to close the show replaying that. So that's how we're going to end tonight. And then I'm going to redirect everyone over to Turtle Boy. So if you want to watch Turtle Boy, we're going to redirect at 9 p.m. I think this is going to be perfect timing, actually. Let me find it. Here we go. So how long is this video? Yeah, this video is about 12 minutes. That will take us right up to Turtle Boy. This is perfect.
Everybody all set?
I'm just gonna play this, and when it's over, you know it's Turtle Boy time. We'll redirect it. We'll all go over to watch Turtle Boy dig out.
My name is Paul Tucker, TCKER. I'm the district attorney for Essex County. I'm here with Chief Gray, members of his.
I just want to say thank you, everybody, for watching. Thank you for sharing. Thank you for subscribing and liking and donating and supporting, especially Kelsey. Again, we're up to, on Kelsey tonight, I've been watching that go up all night. We're at $12,326. That's amazing. Before we started, we were under 10 grand. So you guys have been amazing tonight. I want to thank everyone for donating to Kelsey tonight. And thank you, Attorney Mark Bederow, for giving us his 2.5 hours. He was amazing. He was great as usual, as he always is. So I'm gonna check out, and we're gonna play this video, and then we're gonna redirect to Turtle Boy. I just want you to check out this police chief, because he gets asked about body cams. Look how quickly he doesn't answer the question about the body cams. This police chief, I'm telling you, I'm gonna do a special. My next show is gonna be on this police chief. We're gonna look into him. All right, I'll see everyone over at Turtle Boy. Let's go watch this police chief. This will be it for the night for us. And then we'll head over to Turtle Boy.
Command staff.
Have a good night, everybody. Thank you.
First, let me say thank you all for your patience last evening. As you can imagine, when an event takes place at 6 p.m. and we're all looking for answers, I know you had lots of questions last night. The public had lots of questions. But we thought that everyone would be better served by getting as many preliminary facts as we could, and then putting it out today, obviously with an eye toward being as transparent as we can, given the circumstances. Last evening, shortly after 6 p.m., 3 North Andover police officers went to 125 Phillips Brook Road in North Andover. The purpose of going there was to serve a court-approved restraining order. The subject of the restraining order was 28-year-old Kelsey Fitz Simmons. Ms. Fitzsimmons was an off-duty North Andover police officer. She has approximately 1.5 years on the job here with NAPD. 3 North Andover police officers were on the scene, one of whom was a supervisor. When one of the officers was escorting Ms. Fitzsimmons during the service of the court order, a non-confrontation took place. As a result of that non-confrontation, one of the responding officers discharged their weapon, which struck Ms. Fitzsimmons once. She was immediately given medical care. She was med-flighted to a Boston hospital, and as of this morning, we're told she is in stable condition. The officer that discharged the firearm is a veteran officer, having served over 20 years with the department. Now, as you can imagine, we're only about 16 hours out from this incident. There are still lots of questions. There's an ongoing investigation. Currently, the investigation is being done by Massachusetts State Police detectives assigned to my office at the Essex DA's office under the direction of Captain John Costa and Detective Lieutenant Robert DeMeo. There are lots of interviews to be done. There are lots of pieces to be put together. There's lots of things that remain unanswered. But for now, we want to make sure that the people of North Andover and across the Commonwealth know as much as we can give out at this time, being as transparent as we can. We also know that serving restraining orders, court-approved restraining orders, are sometimes some of the most dangerous duties that police officers uncover, no matter who the object of that order is. Chief Gray has been a great partner with us, not only through this investigation, but through many others. I wanted to make sure we give the chief an opportunity to speak, particularly about his officers, and sometimes we worry deeply about the wellness of our police officers, well, particularly in difficult circumstances, so they're in our thoughts. Chief Gray.
Thank you, sir. Thank you. Just some quick words on what happened. It's an ongoing investigation, like the DA said. There's not much we can talk about. We're concerned for all the officers on duty and off duty, and we're just going to monitor and hopefully get some results.
Okay. We will be able to take some questions, and to the extent that the chief and I are able to answer them, we will. As you can imagine, over the next few days, we'll probably be getting more answers. There are lots of interviews being done. Our state police detectives worked well into the night last night. We spoke with them this morning. They're already out this morning. So to the extent that we can answer some questions, we will. Some we may have to defer for a little bit more time. We're going to make sure that what we do give you is accurate information rather than speculation. I know you all appreciate that as well. So having said that, we can take some questions and we'll do the best we can to answer.
Was the officer, was the off-duty officer armed, and what precipitated the on-duty officer to fire at her?
So what we're saying is accurately that there was an armed confrontation. In terms of the details of that and how that came to be, it was during the service of the court-approved restraining order. But the very granular details, we're waiting to speak on until we get the interviews back from our state police detectives who are speaking with the North Andover officers that were involved.
How about the restraining order? Can you tell us at all the nature of that? Who was it for, et cetera?
So I can't comment on who the plaintiff was, but I can tell you that a court order, there are check boxes. Oftentimes it's stay away from, no contact, and turn over all firearms. So the restraining order was a standard 209A filed by the plaintiff and served by the North Andover office.
Were the officers going to retrieve her weapon?
Pursuant to the court order, one of the standard boxes to check is retrieval of any firearms in the home. That's standard operating.
Can you say where she was struck?
No, I'm not going to comment on the medical condition at all.
Can you say how many people were in the house at the time, including Ms. Fitzsimmons?
I can tell you that there were 3 North Andover police officers. In terms of other people in the house, until I get the full reports back, I won't be able to tell you how many and who they were.
Is there any body camera footage of what happened?
We're actually looking to see what camera footage is available. I have not seen any, and I don't have any reports on any.
Do North Andover police officers typically have body cameras on when they're executing these court orders?
No, the North Andover Police Department does not use body cameras at this time.
Can you speak at all to her mental health, and also was this related at all to her efforts to have, her weapon was taken away from her, and then she had sought relief in the courts, and I think it was Friday she dismissed that. Is this related to that at all?
So the scope of our investigation right now is the actual armed confrontation. I'm sure that there'll be further information coming out. I'm sure that North Andover PD will be looking at that as well. But in terms of commentary on her mental health, I'm not comfortable speaking on that at this time.
Can you talk at all about the efforts that, she sought to have her weapon given back to her? Can you speak to that at all, what that situation was and why?
So, Chief of Personnel Matter?
Personnel matter, yes.
Okay.
Chief, sorry, go ahead.
Yeah, no, it is a personnel matter, so we weren't going to speak about anything like that. Yes, ma'am.
I know you guys are pros, but can you speak about how you're all feeling today? Not just the 3 responding officers, how you're feeling? What's the mood?
I mean, it's a critical incident, and like a lot of critical incidents the police officers deal with, we all have our own way of, getting through it, whether together or by ourselves, and this is no different.
Chief, she was a member of the department. Did she know the officers who were coming to her home? Did everyone know each other?
I would assume so, yes.
Can you talk about her as an officer on the department, what she was like, why she wanted to become a police officer?
At this time, I'm not comfortable talking about that sort of thing.
How about in terms of charges? I mean, will there be some charges at some point in time? And I would ask you just one other thing, that we have reports that she may have been involved in an incident in Maine at an Airbnb over the weekend, and then was involved in an accident on the Maine Turnpike. Is there any truth to that? Can you speak to that at all?
Not specifically as to what occurred prior to what we've spoken about already, but with the lead up to it certainly would be something that would be part of the investigation. And you had a first.
I just wondered about, charges, at what point in time would she be charged? Would you wait till she came out of the hospital? Do you know how long she might be there, et cetera?
So we don't know how long she'll be treated. The good news is that she's in stable condition. In terms of charging, there will be meetings between our state police detectives and our senior trial team. We've already met this morning. As of right now, I can't tell you what those charges will be, except to say that our senior trial team will be working with the detectives, and to the extent that charges will come forward, they will fit what took place here.
Well, I'm sorry to, but in terms of what's her status with the department right now, Chief? Is she suspended, administrative, et cetera?
Right now, it's on administrative leave.
How about the other officers that are on leave?
Again, this is like the DA said, it's 16 hours old, so we're assessing the other officers, and we're going through our policies and determining what sort of actions may be taken as far as time off or any sort of other methods.
Are you able to say how long she's been on administrative leave?
I think I'll just leave it that she was on administrative leave. And I also.
At the time of the incident, she was on administrative leave?
She was, we'll just say she was on administrative leave, and that leave obviously is now going to be extended. So we'll just leave it at that. I do want to make a comment, though. There's been 3 questions, and I think that all of them are very good questions when it comes to officers' mental health. And think about the things that police officers have to face. Now, you take a look at the circumstances that are known to us that occurred in this particular incident. We worry deeply about the mental health of our officers. I know Chief Gray does worry greatly about his officers, as do I. I was a 32-year police officer myself. I know the struggles that the officers have, and I appreciate the questions. And I just don't want it to be lost in the swirl of the headlines that these are humans. These are police officers that have to make quick decisions, that use of potentially using deadly force.
You see how he's backing up the police? He's a former police officer, police chief himself. A little bit of bias there, DA, right? He's all about the police officers, except for Kelsey.
This is something that should not go unnoticed or unappreciated by the public. So I appreciate your questions on that.
Is she under guard at the hospital?
So we never comment on if somebody's under guard or what the security is at the hospital. That's just something that we routinely do not comment on.
I sort of asked this question before, and you may have said that you couldn't answer it, but related to her weapon, did she have it in possession at the time of this or not? I know you said that the boxes are checked, and has her weapon been returned to her? Did she have it?
So we're not commenting on the weapons. All I can tell you is that on the order, we're not
going to comment how the police screwed up here. We're not going to comment on that. No comment, Paul Tucker, right?
The checkbox, if there were weapons home, to retrieve them, which we would have done if they were there. All right? All right. Well, thanks, everybody. Again, I appreciate your patience last night and coming back today. I know this is a matter of great public interest, and we wanted to make sure that rather than come out last night and not really have much for you, we rather than be expeditious about it, we wanted to make sure that we were accurate and factual. So to that extent, I want to thank all of you for coming back. So appreciate it.
Thank you.
That's it, folks. That is it. All right, I want to thank Glamassus for she's contacted the DOJ on this. I also want to thank her for adding Kelsey's hearing to her spreadsheet. If you know anything about Glamassus and her spreadsheet, it helps a lot of us YouTubers keep up with a lot of these trials and cases. I use Glamassus's spreadsheet, so it's very helpful to me, but I think it's helpful to a lot of other YouTubers too, and hopefully gets the word out to more people. Thank you so much, Glamassus, for what you do behind the scenes. It's very helpful to myself, and I know others, so definitely much appreciated. I also wanted to, before we shut this down tonight, just wanted to go back to my Give, Send, Go because some more donations came in. Thank you so much. Much appreciated on both of these fundraisers. Moria Valesi just made a $20 donation to my GoFundMe, and Rhonda B as well. So I want to thank them both for sending new donations. And Moria Valesi says, get him, M. I'm going to get him. Thank you, Rhonda B. as well. And do I have those up? Yes, I do. Excellent. And I also wanted to share this one, which is Kelsey's, because it keeps going up. It's up at 12,506. Somebody just gave $100, it looks like. And look at these. They're all coming in 6 minutes ago, 1 minute ago, 3 minutes ago, 15 minutes, 22. You guys have been giving all night to Kelsey. I want to thank you so much. I know that Melanie also had it pinned in her chat tonight. So it's great to see you all donating tonight and kicking in to Kelsey. Again, givesendgo.com/help Kelsey heal. That's her Give Send Go. Let me say that again. givesendgo.com/help Kelsey heal. If you want to give a donation to her Give Send Go fund, her defense fund, again, it's at 12,506. And it's also the Young Jurks, givesendgo.com/the Young Jurks, JURKS, if you want to give to my Give Send Go as well. Really appreciate all the people who have been kicking in tonight. It's so much appreciated. It makes a big difference, I got to say. The cost to defend yourself, it is quite expensive. So I just got another legal bill for this month, another bill. So my expenses keep going up. I can't imagine what Kelsey's are right now. So thank you so much for donating. Thank you for watching. Thank you for supporting. Thank you for subscribing. All the new people, if this is your first time watching us or you've watched us before, you haven't subscribed, please hit that like and subscribe button on the way out. I really appreciate you all watching us. Let's go watch Turtle Boy together. I'll see you over there in the Turtle Boy chat. 9:02, he's ready to go. Let's go watch Turtle Boy. He's going to talk about the Mega Motion. He might even talk about Kelsey tonight. So I saw one of the comments in the chat saying that Turtle Boy was fired up about this judge as well, and he may go off as well. So I'm interested to see that tonight as well. I'll see you over there for Turtle Boy Live. Have a great night, everyone. Thank you so much. And again, make sure you like and subscribe, and you check back. I might be doing a live show either tomorrow or Thursday. I'm probably going to do Wednesday and Thursday this week, actually, because I want to make sure we're covering Ken as a new police chief search, and I also want to get into what's going on with the North Andover Police Department as well. So much more shows are coming up. Make sure you like and subscribe and check us out. A lot of times I do them last minute, so make sure you check each night, and we'll see you real soon. We'll see you over in the Turtle Boy chat. Have a great night, everyone. Thank you so much, Mark Bederow. And thank you to my mods, MJ. I want to thank Jen O, who is here tonight. I want to thank Stephanie, who I saw as well, and Sarah and Scott McGinnis, all five of them. I thank you so much. I think I saw all of you in the chat tonight. We'll see you soon. Have a great night, everyone. Oh, one last thing. There's also a new Kelsey Fitz Simmons Facebook group. Justice for Kelsey Fitz Simmons. It's run by a guy named Gator Boy. I'm one of the mods over there. It's a new group. Make sure you look and subscribe or join that Facebook group as well. Just do a search for Kelsey Fitzsimmons groups on Facebook. You'll find us. I hope to see you in the group as well. It's growing. He just started that group. We were talking about starting it on our show. He decided to start it. It's growing immensely. Please join that group as well. I'll see you over at Turtle Boy Live. Have a great night, everyone. Thank you so much. Good night, people. See you soon.